Make please, your lordship.
Yes.
My lord, I beg to mention item number 1, lordship. I may be allowed to withdraw the petition with liberty to file a fresh, lordship, because I have to include some record documents.
Okay, as paid for by Mr. K. M. Majumdar, learned counsel for the petitioner. The writ petition stands dismissed as withdrawn. Stop. However, liberty to file a fresh one is granted as paid for.
Much obliged, lordship.
May I please your lordship?
I'm
Lordship,
for a department in item number 1 for elementary.
Okay, Mr. SMT Chisti, learned counsel appears for the elementary education department.
Apply.
may I please your lordship? Lordship, I beg to mention item 40 of the daily list. The conducting counsel has some difficulty today. Your lordship may kindly take up this matter on some other day.
40.
For petitioner, your lordship.
40.
40.
40. What is this office note?
Lordship,
Just a minute. Thank you. Okay, you are for the petitioner.
yes, your lordship.
As paid for by the learned counsel for the petitioner. Matter stands adjourned for the day.
Deeply obliged, your lordship.
Oh, this matter relates to pension, Malak. There is urgency. Can it be on 26th of this month? He is not receiving his pension in fact, Malak.
This month not possible. After vacation.
Urgency, that is why my humble prayer for
Coming week is a motion week, so not possible.
Oh,
On
let
reopening.
it be in a admission column so that
On reopening.
Malak,
On reopening we'll have it. Give a date.
Malak.
17/7.
Lordship, I beg to mention item number 18.
Item 18.
Yes, Lordship. Lordship, the matter is for non-payment of salary of teachers. For this, we need to file an application for amendment of this writ petition. But some instruction and document are yet to be received from the petitioner, so we need some time. So can the matter be listed after vacation?
As paid for by the learned counsel for the petitioner, matter stands adjourned to be listed again after the ensuing summer vacation.
Really, okay.
Motion matter, lordship, for listing next week, lordship.
Okay.
May please, your lordship. Lordship, 2 cases, my lord, I am praying for listing after vacation. May I pray on 16th or 17th July?
2.
1 admission matter and another is contempt matter. I am praying after vacation. That is on 16 or 17 my lord, July.
Okay. 24, 25 after vacation. Madam, just go.
May I please your lordship?
Yes.
Lordship, item number 17 of the daily list, the petitioner no longer wants to press this case in the court. We
Your
would
good
like
name?
to withdraw.
Your good name?
N. Gogoi,
On behalf of
M. Saranya.
Mr. N. Gogoi, learned counsel appearing on behalf of M. Saranya on instructions submits that the petitioner would no longer want to press the writ petition. In view of above, the writ petition stands disposed of as not pressed.
Obliged.
May it please your lordship.
Yes.
I beg to mention listing of an IA lordship. We have recently filed a lordship. The matter of urgency is that lordship, we have in the writ petition, we have challenged an advertisement from the BTC government lordship. But lordship, there are totally 12 parties, but 10 of them has already been selected in the said exam. And then we have got received directions from the BTC that to strike out the names of the petitioners before Wednesday lordship. So if your lordship may kindly give us
Okay, give a date.
on Monday. We file IA for striking out lordship.
You don't have his position. Huh? 23. What is that? Yes, okay. Monday.
Highly obliged.
May it please your lordship, I beg to mention for listing of a WPC for fresh motion by next week.
All right, you'll get a date. Okay, you'll be listed next week, but not a
Mr.
date will
Commissioner,
be
Item number 38, my lord.
38.
Item number 38. I was supposed to file an affidavit. I'll need a week's time. I got an updated instruction yesterday, my lord. 38, the first motion, first item in
It's
order.
an contempt matter of 2018.
Hmm.
So contempt available option has to imply it,
Hmm.
comply to it. Let the matter be fixed, my lord, just
Immediately on the reopening.
after vacation, my lord,
Let
by
my
fixing a
affidavit be
date,
there,
my
my
lord.
lord. Yesterday I got the instructions.
Give a date after the vacation.
By fixing a date, my lord. Much appreciated.
Obligation.
May I please, your lords?
Hmm.
My lord, with the consent of my lord, other side, my lord, item 41, orders matter. My lord, may kindly take in after a week, my lord, immediately after application, my lord. There is the office not dated 2/6/2025.
Why is it listed for orders today?
Well, for submission of notice upon response 7 and 8.
Has it been served?
Yes, my lord. As per office not dated 2/6/25, notice has already been served upon 7 and 8.
See, let the matter be called up. We'll pass the orders,
Yes.
okay?
May I please, my lord?
Hmm.
My lord, I'm praying for listing up to orders matter, my lord.
Hmm.
Can it be on this Wednesday? Lord? This regarding service report only, my lord.
Only new matters. If it's not a new matter, it'll come after the vacation. All right?
After vacation, my lord, any date, please.
You'll get a date after vacation. Give a date.
Obliged, my lord.
Registry will give.
May I please, lordship? Lordship, I beg to mention a fresh date petition, lordship, for Wednesday, lordship.
Not dates, but we'll allow it any date of this next week, okay?
Obliged, lordship.
You just give your
My lordship, this is regarding the case number 289525. It's regarding a read petition of Sumitra Devi. The last posting date was on 30th of May 2025. It was supposed to fix after 1 week, but today is 28th of June. It has yet not been fixed. So I request.
After vacation, give a date, please. It's an admission matter.
This is mentioned.
29, there are 8 cases.
Read this.
May I please, your lordship? Actually, I'd like to mention an listing an IA for Monday, lordship, IA for correction, lordship. Main matter is fixed on Monday.
IA for correction.
Yes, lordship, the cost title part, lordship.
Okay.
Obliged.
May it be please your lordship. Lordship, as per order dated 21/5/2025, we have filed another writ petition challenge the minutes of the DLC dated 14/11/2017. Kindly take the matter in along with in WPC number 2902/2025. 2902/2025.
2902.
2025.
2902
Yes,
of 2025. There's no urgency, I think. It'll come after vacation.
Services.
Okay. As paid for by the learned counsel for the petitioner, list the matter along with WPC number 2902 of 2025 after the ensuing summer vacation on a date to be fixed by the registry. None appears for the petitioner when the matter is called. List after 2 weeks.
Contempt matter, lordship. Non-compliance of order dated 4th February 2000.
What contempt matter? It's item 4.
Item 4, contempt to part.
Item 3 is main, lordship.
What were you doing? Item 3 was called. No, cancel the order. Show me the order, date, place, page number.
Page number 11, lordship. Page number 12, para 11.
Please read.
So in view of the fact that the petitioner service should have been provincialized as he
is the Hindi teacher of the said school, and as the mistake had occurred due to the making of a wrong staff pattern of the district elementary education officer, the respondents are directed to consider the case of the petitioner for provincialization as Hindi teacher of the said school within a period of 1 month from the date of receipt of the certified copy of this order. So I have submitted the order, Lordship, on 10 February 2025, Lordship. It's page 14.
Who's the respondent?
Respondent, respondent and container number 1 is the commissioner. Number 2 is the director.
Okay, so who is supposed to comply? Which respondent?
Respondent number 2, Lordship, director.
Director.
Yes, Lordship.
So we'll issue notice to number 2 only at this stage.
All respondents, Lordship.
No, a specific order has been passed.
With the prior approval of the commissioner, director can appoint, provincialize the service of the petitioner, Lordship. All respondents are necessary to
Okay, your good name?
MK name, Lordship.
MK?
Name.
Heard Mr. MK Neok, learned counsel for the petitioner, who submits that the direction passed by this court, via order dated 4/2/2025 in WPC number 4067 of 2023 has not been complied with by the respondents, despite a copy of the same having been furnished to them. Stop next para. In view of above, issue notice returnable by 4 weeks. Stop petitioner to take steps for service of notice upon the respondents by registered post with AD due within 3 working days. List again after 4 weeks.
Obliged, Lordship.
Wait, please, your lordship. Item number 4 and 5 may be passed over for the time being. Mr. Sheikh is appearing in court number 11.
4, 5 passed over.
Must close.
Yes.
Well, here notice your notice has not been issued till that night.
Yeah, please, your lordship, madam.
So Mr. H.R.A. Chaudhary can be deleted. His name
Already deleted, madam.
already.
Yes, madam.
When?
Yes, per court order, madam.
Okay.
Wrongly was inserted.
Okay, what is to be done today?
My lord, earlier notice was not issued, my lord. Order was passed for take instruction, madam.
Notice may go, I will take instruction now.
Yes, madam. Notice.
Heard Mr.
M. Islam.
M. Islam, learned counsel for the petitioner. Issue notice of motion returnable by 4 weeks. Mr.
PK Bora,
P.K. Bora, learned standing counsel,
Elementary Education Department,
Elementary Education Department.
1, 2, 6
Accepts
and
notice
7.
accepts notice on behalf of respondent numbers 1, 2,
6 and 7.
6 and 7. Stop.
I R Boru Lordship for response number 5 in item number 7.
Mr. R. Boro, learned. You are the standing counsel.
In item number 7.
No, you are for which?
For 6 and 5
Mr. R. Boro accepts notice on behalf of
AGL.
No, we'll pass the order one by one. Are you there in item number 6? 6?
In item number
6, you're not there. Okay, then who are the remaining respondents?
Finance is there, my lord. Commissioner and Secretary.
I'm for respondent number 4, lord.
Director.
Miss
S4.
S. Kuar, learned counsel appears for respondent number 6. Respondent number 4. So how you have accept notice on behalf of respondent number
1, 2,
1,
6 and
2,
7.
6 and 7. Now who remains? 6 and 7. Finance is not there. Accountant General Assam is not there. Mr. Nayak is there, finance. Mr. P. Nayak, learned counsel, learned standing counsel, finance department accepts notice on behalf of respondent numbers
3 and 8.
3 and
8.
8. Then that leaves us the AG.
My lord.
AG. Huh?
I can repeat.
Mr. Arboro, learned counsel, appears for respondent number 5. Stop. As such, notice is complete upon the respondent. Petitioner to serve requisite copies of the writ petition to the learned counsels appearing today within 2 working days. List the matter again after 4 weeks. Then in item number 7, heard Mr. M. Islam, learned counsel for the petitioner, issue notice of motion returnable by 4 weeks.
I'm for 1, 2, 6 and 7, madam.
Mr.
PK Bora.
P.K. Bora, learned standing counsel, Elementary Education Department, accepts notice on behalf of respondent numbers 1, 2,
6 and 7.
6 and 7. Then Mr. P. Nayak, learned standing counsel, finance department, accepts notice on behalf of respondent numbers
3 and 8.
3 and 8. Then Miss S. Kuar accepts notice on behalf of respondent number 4. While Mr. R. Boro accepts notice on behalf of respondent numbers 5. Stop. As such, notice is complete. Petitioner shall serve requisite copies of the writ petition to the learned counsels appearing for the respondents within 2 working days. List the matter again after 4 weeks.
Obliged, ma'am.
Obliged.
May it please, Lord. Petitioners are assistant teacher of a my lord non-provincialized school, Venture school. Since they are serving my lord 2008 and 2010 my lord, till date my lord. What happened in the year 2020, 23, 23, 24 my lord? Their names has been my lord dropped from the UDIS my lord. Unified District Information System for Education my lord. Their names were dropped my lord, without any information to the petitioners my lord, and just to my lord to accommodate some person, my lord, in place of petitioner number 2, my lord. And my lord, the provincialization of school is, my lord, going on before the concerned authority, my lord.
My lord, it is not a provincialized school, lordship. So their remedy lie in the education tribunal in each district, lordship. So that the remedy lies in the education tribunal. They should approach the education tribunal, lordship. Not the high court.
Section
Yes.
41.
Yes, lord. This school, lordship. Yes. But this is not a government school, lordship.
My lord,
Their grievance is against the school managing committee.
though that, my lord, that provision is there, but the my lord tribunal is not working, my lord.
No, every district judge is lordship and have entrusted with this.
District judges are empowered to,
Yes,
to act as a tribunal.
The tribunal is not in a function, my lord.
How do you say it's not functioning? Or which district?
Lakhimpur district, my lord.
Lakhimpur district.
Yes, my lord.
Are you sure?
My lord. Not only in Lakhimpur district, my lord, in all other districts, my lord. It is not
No,
functioning
it's not
properly,
true.
my lord.
No, is there a statement in your writ petition like that?
No, my lord, that is
Then,
not there, my lord.
then, so why do you bring us such things?
They should approach the education tribunal.
You
Well,
approach.
I'll satisfy your lordship, my lord, kindly fix it on next day.
This is not at all maintainable, lordship.
No, when there's a
I'll
remedy
place orders
available under the
on them before,
statute,
my lord.
when there's a remedy available under the statute, you should first go there. Just because it's not functioning properly, you cannot just come like that. And particularly when you have not made such statement here,
My lord.
we'll relegate you to 41. You go,
Kindly give me some time, I'll satisfy your lordship.
okay, list again after the ensuing vacation, as paid for by the learned counsel.
Same, okay? I to handle it. Discomfortful, no?
And appears for the petitioner when the matter comes.
After vacation.
Although Mr. SM teaches still learned standing counsel. Secondary or what?
After.
You are for secondary or elementary?
Yes, secondary education, lordship.
Secondary education is present. List again after the vacation.
Obliged.
On the date to be fixed by the registry.
Obliged.
Please, your lordship.
Yes.
Petitioners aggrieved because the students of the petitioner school, they have been deprived of the financial benefit under this Mukhyamantri Nijut Moinasoni scheme, your lordship. The petitioners, students tried to upload the application on the official portal, But however, the applications have not been accepted by the portal and no reasons have been assigned for why the applications are not accepted, Your Honor.
Issue notice.
So,
Your good name?
MK Brown.
Hart Miss M.K. Brown, learned counsel for the petitioner, who submits that the petitioner school has made an attempt to avail for the Mukhya Mantri Nijut Moina Asoni scheme. But the particulars they have tried to upload in the portal has not been accepted for reasons not known to them. Stop as such. The benefit of the scheme is being denied to the petitioner, prompting the school to file the instant writ petition. Page 22, you'll get the spelling. Page 22, prayer portion. In view of above, issue notice of motion returnable by 4 weeks. Miss
Your Lordship, I am appearing for Respondent 1, 2, and 3 for secondary education.
Miss, your good name?
P. Das.
P. Das, learned standing counsel, secondary education. Department accepts notice on behalf of respondent numbers
1, 2, and 3.
1, 2, and 3. Instead of that, you write all the respondents. As such, formal notice is not required. Petitioner shall, however, furnish requisite extra copies of the writ petition to the learned standing counsel within 2 working days. List the matter again after 4 weeks.
I'm deeply obliged.
May it please Your Lordship, the grievance is the same. It's only another separate school, but the grievance is the same. Your Lordship.
Similar matter, Your Lordship.
I think we can say same order, similar order, okay? I did not mention the name of the school. No? All right.
May I please? My lord, here we have put to challenge the impugn order of allowing the IS to hold the charge of the principal of the school, my lord. And I am the senior most teacher, eligible and qualified, my lord. Seniority list, Your Lordship will find at page number 43.
Since when?
Since, my lord,
Since when is he holding the charge?
28th February, my lord.
20th of
February 2025. Impugn order. And
Page
I'm the senior most. Before that, I'm taking the lordship to page number 43.
Oh, this seems to be a usual problem, isn't it? Senior most is not given, they come to the court and
Yes. And why they have rejected, my lord, I'm coming to that, my lord. Your lordship, kindly bear with me and please take your lordship to page number 43.
Inspector school is quite a competent authority, Lordship.
My lord, let me finish first. Let me finish.
just a minute, Mr. Chisti, there's one issue, another case also. They say that even to hold charge,
Yes.
qualifications is required.
Qualification is necessary, yes. Okay.
So inspector of school may not be a teacher, may not be having that.
Even he could be qualified for that also.
Qualified.
Lordship. That is why there is something is there, Lordship.
I'm taking your lordship, therefore,
There's something
page
in
number, page number 43 is there. I'm taking your lordship. Your lordship will find I am MA B.Ed, serial number 1, page number 43. And I'm getting, my lord, graduate scale of pay since 1993.
Mr. Talukdar Prukasta
Yes, sir.
will issue notice
Yes,
on
sir.
both the,
At this stage, I need a status quo, my lord, as on today, whatever
why
is there.
status quo?
Because, my lord, they are processing the file to give the my lord charge to the second one.
That is
Second person.
Second person, I
Yes, who
see.
is junior to me. So status quo as on today will do.
Okay,
my purpose.
that is not yet contemplated, Lordship. It is his imagination, his
Not
assumption,
imagination,
Lordship.
not imagination. it's
Lordship,
the
that is
reality.
not pleading in this
That's-
case.
Status quo as on today.
Lordship, that
will-
cannot be a ground to give any status quo, Lordship.
Even
That
then,
someone will be given
if my
benefit
learned
on
and
that,
objects for status quo, my lord, then I can show my lord what they have done, what they are violating the honorable
Let
court's
them
order.
show whatever they want, Lordship.
They are violating the honorable court's order one after another, my lord.
Anyway,
Only
notice
my
should
lord,
go.
notice may go. I have
Notice
no
should
issue,
go,
my
I have
lord.
taken
Status
instruction,
quo
Lordship.
should be maintained, my lord, because I am holding the academic charge of the school, my lord.
He wants status quo on a future actions,
I want
consequences to be, Lordship.
Actions already taken by them, my lord. They have given charge, impugn order is there. What future is?
Where is the statement?
statement, my lord, future,
That they're contemplating to give the charge to the second senior-most.
that is not there.
No,
My
since,
statement is for,
no, since you have made that submission, show me that statement. Otherwise, we'll issue notice only.
my lord, in that case, my lord, I will pray for stay of the, my lord, impugn order, my lord.
You pray the stay, but I'll issue notice, all right?
No, my lord, status quo as on today is required.
no.
Because, my lord, they are.
No, you are challenging the person holding charge. He's the inspector of school.
Yes, sir.
And you're saying status quo, that means he'll continue to remain as inspector of school. So you are contradicting yourself.
Yes, I'm holding the academic charge of the school, my lord.
Maybe.
I'm holding the academic charge of the school.
You hold it, it's okay.
So, my lord,
If you're holding it.
so therefore, this should not be disturbed, my lord. That's my humble
No,
submission.
but that is not your prayer. That I am holding academic and I should not be disturbed. You are challenging this order at page 163.
Yes.
You should know what you want. Heard Mr. B. Prokashta, learned counsel for the petitioner, who submits that by filing this writ petition, the petitioner has challenged the order dated 28/2/2025, bracket annexure 21, by which the charge of the principal of Batadrava Sri Shankar Dev Higher Secondary School in the district of Nagaon has been given to the Inspector of Schools, NDC Nagaon, along with financial powers. Despite the petitioner being the senior-most teacher,
The most eligible, my lord.
just a minute, senior-most qualified and eligible to hold the in-charge principal. Issue notice of motion returnable by 4 weeks. Mr. SMT Chisti, learned standing counsel, higher education.
For all
Department.
the respondents.
Accept notice on behalf, Secondary Education Department, accept notice on behalf of all the respondents. As such, no formal notice is required. Petitioner shall furnish requisite extra copies of the writ petition to the learned standing counsel within 2 working days. Next para, also issue notice on the interim prayer made by the petitioner, making it returnable within 4 weeks as well.
Obliged. A date may be given, sir.
List again after 4 weeks on so and so. On 6/8, okay.
Lordship, the matter may be passed over for the time being, your lordship, after some time. Obliged.
May I please, lordship, in non-payment of salary, lordship. Petitioner is entitled salary from August 2007 to till that, lordship. But my salary.
August 2007,
2007, lordship.
till date.
Till that, lordship.
How are you working without salary?
By this time, lordship.
You're working elsewhere.
Lordship.
You are employed somewhere else.
No, lordship.
Part-time job.
No, lordship.
How
I
do
am
you
still
survive?
working, but I am working under new appointment, lordship.
New appointment?
Yes, lordship.
Where?
They have accommodated me.
Where?
You kindly see the page, lordship.
Where is your appointment order first of all? Show me.
My first appointment order is lordship page 27, lordship.
Serial number? No, this is what? This is the name of schools.
Yes, lordship. Appointment letter is 30, lordship. Page 30. This type copy. And original one's 31, lordship.
30.
30.
This is for Viva Voice. He's calling you for Viva Voice. This is not appointment order.
This is Viva voice, lordship. 32 is the appointment order, lordship.
Arun Kumar Devnath. This is a petitioner.
Yes, lordship. There have been, thereafter, lordship, I have been accommodated by page number 72, lordship.
Assistant teacher of Kalyanpur LP School.
Yes, lordship.
The date is 89. 19/12/1989.
Yes, lordship.
Where is your accommodation?
Accommodation page 72, lordship.
Page 70.
72.
Accommodation where?
In the same school, the Arrear school, lordship, when initially appointed.
No, why accommodation is required?
Sir, because by this time, my service has been declared irregular appointment, Lordship. My appointment. has been declared
When was it declared irregular?
Prior to this appointment, Lordship.
Lord, Lordship, there's a large scale of illegal appointments in basically 4 districts, including Dhemaji. So there were some court cases earlier, and honorable division cases directed it to held scrutiny, Lordship's screening committee to scrutinize all those illegal teachers. And accordingly, advertisements were made, and they have participated along with large teachers, Lordship. And ultimately, they were found to be irregular teacher.
Not illegal.
Not illegal.
Irregular.
Here, I think I have to take instruction whether I think they are irregular. That's why they were accommodated the tutor because they didn't have the requisite qualification.
Page 72.
And there was a condition that they will not claim any arrear salary, and they will be appointed at fresh as a tutor.
Please read this order. Let us see what it says. Annexure P.
Annexure and page 72 is a
Yes.
72.
72 is the accommodation letter.
Yes.
Let us see how it is.
It is not legible in our Lordship, in our petition. They have given such an illegible Lordship copy, Lordship. They should have given.
Why you have given? You should give first class.
At least
First class copy to everybody.
It should have been typed, Lordship. Type it out properly.
See, by giving such kind of copies, you spoil the mood of the court. Then you'll not get relief.
I apologize for
After all, we are also sensitive.
because
We are wearing specs,
effective one.
high-powered specs. And if you give such kind of copy, then we'll have to.
I will get it.
And by this accreditation, they have already forfeited their claim for area salary, Lordship. They were given fixed pay of 10,000 with Lordship per month.
10,800.
10,800.
We'll issue notice. You please change this copy, okay? Heard, Mr.
MK Neog.
M.K. Neog, learned counsel for the petitioner, who submits that by filing this petitioner, the petitioner is seeking for a direction for payment of area salary of the petitioner from the month of August 2007 till date. We'll stop. The learned counsel submits that although the petitioner was initially appointed on 19/12/1989, he was subsequently adjusted,
And my service was
oblique
confirmed.
accommodated as tutor in the same school by order dated 31/2021. What did you say?
My service was confirmed 7/2/2023.
Where is that?
2003, Lordship. Synopsis I have written, but
Not synopsis.
Those
Any
those were all gone, Lordship. They were all held to be irregular teacher, Lordship. So those
unless you show me
count, Lordship.
unless you show me the order, synopsis will not do.
When they faced the screening committee, their earlier service conditions, they were all gone, Lordship. They
Next
were held to
para.
be irregular teacher.
In view of above, issue notice of motion returnable by 4 weeks. Mr. SMT Chisti, learned standing counsel, secondary education.
And
Department.
elementary, Lordship, here. This is
Sorry?
elementary. This is
Oh,
elementary.
okay.
Yes.
Are you accepting also?
Yes. One.
Learned standing counsel, element. You are both for elementary and secondary.
Yes.
SMT Chisti, learned standing counsel, elementary education, accepts notice on behalf
1,
of
3, and 4.
respondent numbers 1, 2, 3, and 4. Who else are there?
And C is for finance.
For the respondent number 5.
And Miss R.M. Barua accepts notice on behalf of the respondent number 5, Finance Department. Stop. As such, notice is complete. Petitioner to serve requisite extra copies of the writ petition to the learned counsels appearing for the respondents within 2 working days. Stop. It is also seen that annexure P is not legible, and therefore the petitioner shall replace the same with a typed copy and furnish a copy of the same to the learned counsel for the respondents. Requisite copies to the learned counsel for the respondents.
And my submission, Lordship, that they.
Next para.
Yes.
At this stage, Mr. SMT Chisti, learned standing counsel, Elementary Education Department, submits that there were certain illegal appointment made in 4 districts, including Dhemaji, and a division bench of this court had directed that their service particulars be scrutinized. Who stopped the petitioner appears to be one such teacher who was appointed from the Dhemaji district. And apparently, the constituted scrutiny team have found the appointment of the petitioner to be irregular. And that is why a fresh order had to be passed to accommodate him as tutor, with a specific clause stating that the accommodated person will not claim area salaries.
And it is a prospective appointment, so it is clear.
And it will be treated as a prospective appointment.
From 1/11/2020 only.
Full stop. Next para, be that as it may, the rival contentions will be considered at the appropriate time. Respondents to file their counter affidavit. Yes.
Obliged.
My lord, I am sorry, my lord. Lordship, item number 9, lordship, could not appear, lordship. Item number 9, lordship.
You come after vacation.
Lordship, my appearance, man, kindly, lord.
Item 9. I need to write item 9. As paid for by the council for the petitioner list after the vacation.
My lord.
On a date to be fixed by the registry.
We have filed an affidavit, lordship. We have already issued a compliance order rejecting the claim of the petitioner because his service was not at all provincial.
Where's the order?
I think I have given the
Affidavit.
affidavit I have filed.
When? You have received copy?
Yes, madam. We have filed reply also.
15/5/2025.
Don't convert the contempt
I have
petition.
filed my reply on 13/6/25.
No, don't convert the contempt petition into a writ petition or writ appeal. If something is done,
But my lord, PPO has already been issued, my lord, thereafter, my lord.
where is the,
Last page of my reply, my lord, page 79.
no, affidavit of opposition, is it?
Lordship, 15/5, I have filed, lordship. It is there by the director. The director secretary.
By?
Last month. No, not with 5%. By the secretary, lordship.
Secretary. Do you know what page it is?
I have filed on 15/5/25.
Is that?
KS Gopinath,
Page 58, lordship, kindly. Page 58,
58.
yes.
What is the name?
Kunjamai Bordolo, Nayan Kaur is filed a contempt petition.
Narayan Konwar.
Yes, Nayan Kaur has filed the secretary, lordship.
Okay, now before reading this affidavit, I want to see the order of the court.
Yes, order of the court of before.
Annexure A, my lord, page 22/23. Operative court. In the contempt petition.
Last paragraph, in the, may I read, lordship?
Okay.
If found eligible only, the direction was.
PPO issue pension bias.
It wrongly right median, no?
Then in your affidavit,
Yes, then my affidavit lordship come to, we have filed by the secretary. Lordship, page 63 is a order lordship issued by the secretary.
secretary means of what?
Secretary, Department of School Education,
Okay.
page 63, Annexure A.
What was the husband of the petitioner?
Husband of the.
Teacher?
Teacher, head pandit of Chinatown High School, LP
Head
school.
Pandit.
Head pandit, headmaster,
Okay.
LP school.
Page 63.
Page 63, Annexure A.
Okay.
Finding lordship, it appears that the petitioner husband late Govind Chandra Bordoloi was an LP school teacher and had worked under the Karbi Anglong Autonomous Council, DIFU, and his last place of posting was Sainagaon LP School in the district of Karbi Anglong.
late Gohai Chandra Bordoloi, Gohin Chandra Bordoloi had retired from the state school as a head pundit at the age of 58 years on 29/4/1998. Though he had approached before the authority regarding a pension and other benefits, but without receiving his pension, he died on 5/2/2006. The petitioner has claimed for a release. Petitioner has claimed to release her family pension and all other post-retirement benefits along with the interest within the stipulated period in pursuant to Honorable High Court's order and directions dated 29/11/2019, passed in WPSN so-and-so. Since the matter relates to Karbi Anglong Autonomous Council, this department has forwarded it to the District Primary Education Officer KKAC for speedy disposal of the matter by department letter dated so-and-so. But in response to this department's letter, the District Primary Education Officer Karbi Anglong Autonomous Council DFUP had letter dated so-and-so dated 3/12/2020 has informed that without provincialization of the service of late Gohin Chandra Bordoloi, the DPEO Karbi Anglong DFUP could not forward the pension papers to the Director of Pension, Assam, for finalizing his pension proposal posthumously. It is also mentioned in their letter that the name of late Gohin Chandra Bordoloi, expired LP school teacher of Sainagaon LP school under Amri block, was not included in the list of LP school teacher for provincialization due to non-availability of his service book at the time of processing. Hence, the name of late Gohin Chandra Bordoloi was left out from the list of provincialization of services by the DPEO Karbi Anglong DFUP. Decision, Lordship. There is no such provision in Assam Education within bracket provincialization of service teachers and reorganization of education institution within bracket Act 2017 for provincialization of service posthumously. Accordingly, the provincialization of service of late Gohin Chandra Bordoloi, retired head pundit, Sainagaon LP school under Oguri Circle of District Karbi Anglong is hereby rejected for not having any such provision in Assam Education Provincial Service to Teachers and Reorganization Act 2017. So his service was not provincialized during his tenure, Lordship, by the Karbi Anglong Authority, Lordship.
Mr. Chisti.
Yes.
Are there not some cases filed for posthumous provincialization?
There's no such provision in 2017
No,
Act.
provision is not there, but have you come across any writ petition filed like that? Posthumous provincialization in order to get pension.
From my knowledge, this
I have come across in Nagaland.
but here I have not. I think I
You
have
have
not found.
So some provision is mentioned here, Act of 2017.
Yes.
So at any rate, I think you'll have to challenge this.
No, my lord,
Otherwise-
PPO has been issued, my lord. I am regularly getting my pension, my lord.
PPO,
PPO has already been issued. I am getting regular pension monthly.
then what
And
is
my lord, I
what?
have enclosed those letters, my lord, in my reply affidavit.
So if you have that PPO and getting pension, then why is it pending? We close it then.
My lord, regarding, my lord, the interest part, my lord, there is an order for interest, my lord, and the calculation is wrong, my lord. They have calculated from 2003, my lord, but not actually that. I have enclosed that order.
Show me that document.
Yes, ma'am. No, yes.
You have filed what? Reply.
Reply, my lord.
Page number?
Next, yes, my lord, only.
Page number?
Page number, reply starts from 65 page, petition, my lord. The annexures are page 78 and 79, my lord.
But that 65 is not there in my copy. It ends at 64.
65 is not there. Take it one at a
When did you file reply?
I have filed on 13/6/25.
Last Friday. Huh?
Not taxi, this is last proposition.
Did it.
1/3. I have.
Yes. Yes. I think it has not been tagged.
Oh, elementary, 49.
Forty-two lawsuits, we have sent the proposal, we are waiting for approval from the government lawsuits. So matter may kindly taken up after vacation lawsuits. In the meantime, we will get the instruction, that necessary instruction from the government lawsuit. We have all, yes. Yes, lawsuit. Yes. Itu apa? Kalau wait for. Oblige. One appears, and here also lawsuit, the respondent, it is a contempt. It is a contempt, but in the causally lawsuit, it is shown as secondary education. They have, and the respondent one, she is no longer holding the post also lawsuit. She is suffering from the disease lawsuit from cancer. So she is no longer holding for last 2 years. And they have to implead the new incumbent. Yes, lawsuit. That is a picture. Lordship, respondent one. And in her place, Nayan Kaur is holding the charge at present. Yes, Lord, she is not holding the post. Oblige you, Lord.
on 3/3/2025, sorry, 24. Petitioner was directed to take steps for service of notice upon respondent number 9 by registered post with AD due, as well as by way of Dusty. Stop. It appears that he has taken Dusty steps and the respondent number 9 has acknowledged receipt of the notice as per the office note dated 3/6/2025. Stop. Accordingly, notice upon respondent number 9 is accepted to be complete. Stop. Since petitioner is not represented today, let list the matter again after the ensuing summer vacation. Just a minute, just a minute. He's there, sitting there, Mr. Sheikh. Mr. Sheikh, I'm dictating order in your case and you're sitting there, chit-chatting.
I'm sorry.
Huh?
Item 45 to আপনার নয় নি?
Item 45 is your case.
My lord, here in this case, my lord, actually arrear salary is the matter. Arrear salary is not paid. Last occasion, my lord, it is the third time it has come. Okay? Oh,
Who is respondent number 9?
My lord.
Who is respondent number 9?
My lord, my junior has not come with record, my lord. It may be take, but some.
Please write, continue. Later stage, Mr. M.A. Sheikh appears for the petitioner. Be that as it may, let the matter be listed after the summer vacation. You come again after summer vacation.
Next item, item 46, my lord, I paid for adjournment.
Why? What is this matter?
Review, my lord, my senior to become difficult.
Who is your senior?
Yes, Botagulos.
S. Botagur.
Yes, Lord.
What difficulty?
Next week, Lord.
You know very well next week is motion week.
Then after vacation.
But why not today? Anything there in the review petition? Yes, who's appearing? You're there. Tribunal. Anything to review?
Everything has been decided in the proper manner, Lord. So no prima facie error is there on the face of the record, Lord.
Mr. Counsel, you're not aware about this case. You are not there in this case. Are you there?
Fix for after vacation.
Mr. S. Botakur, learned counsel for the review petitioner is said to have some personal difficulties to appear before the court today. Although Mr. S. Tahibildar is present. Stop. In view of above, let the matter be listed again after the summer vacation on a date to be fixed by the registry.
Lordship. P. Chakrabarty for
Ah?
AG. AG. On behalf
Who?
of P. Chakrabarty.
Come and speak in the microphone. I can't hear you.
Appearing on behalf of B. Chakrabarty, sir, for AG in item 46.
In item 46, AG is also there. AG is also there. AG appears for whom?
P. Chakrabarty. P. Chakrabarty, sir.
Huh?
Accountant General.
Miss, your good name?
Tinlong on behalf of P. Chakrabarty.
Miss Tinlung, learned counsel appears on behalf of Mr. P. Chakrabarty, standing counsel AG Assam.
In this case, my lord, PPO already issued, my lord, but PPO already issued, my lord. But amount has not released, my lord.
Amount will come.
Yeah, it will come, lordships. We have sent a proposal, they have issued the PPO, lordships. Now everything is done.
You cannot spend PPO. Amount will come.
Yes. lordship.
You need to pursue.
You pursue the matter. Mr. K.R. Padgiri, learned counsel for the petitioner fairly admits that the PPO has been received by the petitioner, but the amount is yet to be to be given to the petitioner. Mr. SMT Chisti, learned counsel, are paying for the.
I'm for respondent 1, 2, and 3.
Respondent numbers 1, 2, and 3.
1, 2, and 4.
1, 2, and 4.
1, 2, and 4. And
And
my
Mr.
friend is for 3. For 3.
B. Diori, learned counsel, are paying for respondent number 3. assure that the amount which is due to the petitioner will come in due course?
We have complied. We have issued the proposal. They have sanctioned it. Now it is pending in the treasury. So we have complied. It should be.
And it's only a matter of formality.
The matter may be closed.
In view of above, the contempt petition stands closed with the understanding that the respondent authorities shall ensure
Yes, yes, yes.
grant of the pensionary dues to the petitioner without delay.
Oblige. Oblige.
Please call the Jamadar. Okay, no one is there. None appears for the applicant when the matter is called. No, not applicant, petitioner. None appears for the petitioner when the matter is called. Although Mr. If Learned Counsel appears for the
Elementary education
department. For ends of justice, list again after the ensuing summer vacation on the date to be fixed by the registry.
Well, can it be taken up at 2, my lord? Mr. B.
Why?
Kothik has some difficulties in the first half.
At 2 o'clock.
Supposing court also has difficulty at 2 o'clock, then he'll come after vacation.
I'm ready, my lord. Some urgency is there, my lord. I'm ready for today, my lord.
What is the matter?
Matter in this matter, my lord. My lord,
File is
2000.
not also me.
File is not with you,
Yes, ma'am.
but you must know what is the matter.
My lord, 2013, my lord, January, my lord, along with me, my lord, all the staff of the school provincialized, my lord, sanctioned. My post was also sanctioned for the post of science teachers, my lord. Subsequently, another science teachers will approach this honorable court and obtain one interim order. Therefore, for this interim order, my lord, my post was kept vacant, my lord. Ultimately, my lord, this honorable court is directed to hear all the parties and pass the necessary order. Therefore,
Petition is pending.
Yes, my case, my lord. Therefore, my lord.
Writ petition is pending.
No, my lord. But dispose, I finance all these orders here.
Writ
Then, my lord.
writ petition is disposed of.
Yes, my lord. Therefore, my lord, after this honorable court direction, my lord, inquiry conducted, my lord, by the DLSC, my lord, and found that I am the senior most teacher, according directed for the appointment. Then, without taking any action, I again filed a writ petition, my lord, in presence of all the learned council, my lord, education department, my lord, my matter was disposed of, directed to applying the 2011 Act to provincialize my service. Then, without any action, I filed a contempt case in 2021, my lord. Then this matter was pending till 2024. Then they have realized that after more than 2.5 years, my lord, they filed this review petition.
Whose judgment is sought for review?
My lord, the director. Directors filed this review petition, my lord.
No.
Oh, sorry.
Which order is sought to be reviewed?
Yes, my lord.
Passed by whom?
Yes, my lord. My lord Justice, my lord, Butcher Borosar, my lord.
Are you sure?
Yes, my lord. Lordship, in the review application, can you have a look at that order?
Page number?
Page number, my lord, 60.
Okay, it's written here, yes. Call your counsel at 2.
Yes, my lord. Deeply obliged.
Lordship, in this matter, principal has forwarded the lordship the calculation to the department lordship, and it is under scrutiny of the auditor lordship in our department. So after this examination is verification is over lordship, we'll forward it to the lordship to the government lordship. Now it's in the director's office under verification of the calculation.
Director of which?
Higher education lordship. Always has forwarded it. Now we need
To be forwarded to whom?
to the director lordship.
No, director will forward to whom?
To the director, and the director will, after verification, it forward to the government. That's second.
Government, secretary.
Government for Lordship sanction.
What is the matter regarding?
Matter relates to my lord.
The benefit, MSCP, MSCPS benefit.
My lord.
Okay.
It's the benefit given to the petitioner, my lord. Stop with effect from May 22.
Okay, please write down.
Approach this honorable court.
Okay. Direction of this court was to grant the petitioner MSCPS benefit. Mr.
Yeah, Tahbildar.
A.R. Tahbildar, learned counsel appearing for respondent number
One Lord.
1 submits that the matter is currently with the Director of Higher Education Department
Scrutiny is going.
for scrutiny and verification. Stop. Once the same is done, comma, the matter will be sent to the government
For necessary.
for approval. So stop. He therefore prays that the matter may be adjourned for at least 2 weeks.
So the Lordship, it will vacation after the 2 weeks, it will be difficult, Lordship, because the auditor is also on some other purpose.
Okay, adjourn for at least 3 weeks and to enable him to come back with proper instructions. To stop. Miss,
Two Lordship.
the good name?
D. Borkutin.
Is D.
D.
Miss D. Borpuchari, learned counsel appears for respondent number 2. To stop in view of above, that the matter will listed sometime in August, first week, on 8th August.
8 August.
Lordship, regarding Lordship, that approval, but Lordship has been the director will forward for approval, Lordship, for necessary action, Lordship, that may be different, because if something is found wrong in the calculation sheet, so that may not be also. So
After approval,
not approval, Lordship.
instead of approval,
Instead of it's for necessary action.
replace it approval by necessary action.
Lordship. Obliged.
For in this case, we have filed an application to IA, my lord, for the impleadment, my lord, 1773, but they have filed an objection, objecting the impleadment.
You are?
We want to be impleaded in this writ petition. my lord.
You're not a party.
I'm not part.
Okay.
Although we have filed our affidavit from Secretary Department, your Lordship, respondent.
What is the matter regarding?
May it please your lordship, the matter pertains to the non-payment of subsistence allowance, your lordship. And basically only for that and other, in this issue, the other crucial aspects is pending before the educational tribunal. And in their affidavit in opposition as well as the impleading petition, your lordship, if they have any grievance against me, then they may approach the educational tribunal. It is sub judice or about the other crucial aspect. I'm only for the subsistence allowance, your lordship,
Okay, let us see.
as per order of this honorable court, which I have annexed a, yes, your lordship.
Where's your prayer? Let's see.
My, it is the order, as per the order, your lordship. As per the order, at page 40, the operative part of the Honorable High Court is at page 51.
No, the prayer made in your writ petition. What is
There
the?
is to give me my subsistence allowances. And the impugn order, your lordship, at page 57.
Just a minute.
Which I have challenged before your lordship.
Just a minute. To release the area's salary.
Me too, Abdul Salam. Here, your lordship, I would like to draw your attention towards the 4th paragraph. 4th paragraph, your
Just a minute. Where's Annex 11? Page 57.
page 57.
You're praying for setting aside of this order, isn't it?
They are praying.
Of course, that's what I'm saying.
For setting aside,
Yes, what is this order?
your lordship.
Please come to page 57. Impugn order.
Yes, Your Lordship.
Please read.
Where the Goff, white letter number E291975/7 dated 28/4/2023, submitted the entry report received from the District Commissioner of Dhubri District. Whereas the District Commissioner, Dhubri District, is of the opinion that Manora Begum, assistant teacher additional, was deprived of provincialization of a post as per the word given by the SMC to her father, late Sabed Ali, who donated land for establishing the building of Motisar High School, District, Dhubri. Whereas Muhammad Abdus Salam Sarkar, headmaster of Motisar High School, District, Dhubri, manipulated the attendance register and the resolution book of the SMDC regarding appointment in respect of Ashraf Ali, assistant teacher, and Saira Khatun LDA, and as such, Ashraf Ali, assistant teacher, and Saira Khatun LDA had obtained their appointment by fraudulent means. Whereas sufficient evidences have been found to draw disciplinary action against Muhammad Abdus Salam Sarkar, headmaster of Motisar High School, District, Dhubri, and Ashraf Ali, assistant teacher, and Saira Khatun LDA of the said school. Therefore, pending withdrawal of departmental proceeding, Muhammad Abdus Salam Sarkar, headmaster of Motisar High School, District, Dhubri, Ashraf Ali, assistant teacher, and Saira Khatun LDA of the said school are hereby placed under suspension with immediate effect as per provision of Rule 6.1 of Assam Services Disciplinary and Appeal Rules 1964. During the period of suspension, Muhammad Abdus Salam Sarkar, headmaster of Motisar High School, District, Dhubri, Ashraf Ali, assistant teacher, and Saira Khatun LDA of the said school will receive subsistence allowance as per rule. Further, in the interest of public service and under further order, the inspector of school DDC Dhubri is hereby temporarily allowed to hold the charge of headmaster of Motisar High School, District, Dhubri, along with financial power as per provisions of FR 49C to draw and disburse the salary, etc. of the staff of the school vice Muhammad Abdus Salam Sarkar suspended.
Okay, so you have challenged this order.
Yes.
Suspending you
Yes.
and pending
Review.
withdrawal of the departmental proceeding.
Yes, Your
Now,
Lordship.
departmental proceeding has been drawn.
No, not yet. It's already lapse of 1 year.
What is pending before the tribunal?
Tribunal is, Your Lordship, come to
Who has
The-
gone to the tribunal?
me.
You have gone to the
One of the leader. There was several round of litigation. It was disposed of by this honorable court, Your Lordship. I have annexed the
which case?
High Court, yes, at page annexure 8, Your Lordship. The operative part is at page 51.
51.
No, who
51.
who has filed this writ petition?
This is a consolidated judgment, Your Lordship, passed by the single bench of this honorable court on
Who are the writ petitioners? You also one of them?
yes, Your Lordship. There
What
are
did-
5 numbers of writ petitioners.
Okay, what did you challenge?
My challenge is I am a non-teaching staff of the Motisar High School, Your Lordship. And I have been appointed as per the resolution of the managing committee, which I have annexed here. Annex, and that is the precise fact before Your Lordship. And after that, my services has been provincialized with effect from 1/1/2013, Your Lordship.
Just answer my question. What did you challenge in that writ petition? That's all.
Or that is
Don't
only
tell me the whole story of your.
service that my services to be regularized.
Sorry?
Already it was provincialized.
Ah.
Already my service has been provincialized prior to 2013. Then one of the 4th grade employee, Mahmudul, it is clearly, I have already here annexed the order, Your Lordship. If you come to the order, then it will be very much clear, transparent. The judgment, Your Lordship.
Yes.
That is a considered judgment, Your Lordship. Since the matter in dispute are related to the same, arise from the same sets of facts, Your Lordship. It is at, may I be pleased to read over the operative part, Your Lordship.
Just a minute. Let me read myself.
Statement detail. এইটো পুৰা হেৰি আছে তাত নকৰিলে আপুনি খালি মই তাৰপিছত দিম
So a number of writ petitions was filed.
Yes,
Then ultimately it was referred to the tribunal.
if your lordship.
Now you have filed this writ petition claiming for the subsistence allowance. Now,
And another, yes, your lordship, another, your lordship.
now, yes, another what? And that matter still pending there.
Yes, pending there. The
Okay.
other crucial aspects, all other, because your lordship, in this order of this honorable court, at paragraph 17, it was clearly that since it is a disputed question of fact, so on the basis of which the scrutiny committee, Dhubri, has passed its order on Iman, based on 27/6/2014, the same cannot be considered. Yes, it is my appointment, they said, all others' appointments are dubious. It's a doubtful, and therefore it is completely a disputed question of fact, and therefore they may approach the education tribunal for clear findings of the fact. So on that basis, I have approached myself, the petitioner of WPC 6756/2014 at page 48 at paragraph 6, your lordship.
And also 516. You had filed 2 writ petitions.
Yes, as per this honorable court's order, I approached the education tribunal within time, your lordship. Then they even the honorable, even the state respondents have filed their affidavit also, and it is found affirmative in respect of my appointment. But there are some procedural errors, and therefore the honorable education tribunal Dhubri has asked me to file a phrase application, education petition, after completion of the procedure. That means section 80 petition I have not. With that order, I have annexed here at page 53, your lordship, annexer 9.
Why is it listed today? For?
Then it was, Your Lordship, then while it was pending before the Education Tribunal, it was disposed of, and immediately they have reinstated me and releasing my salary. And till May 2023, Your Lordship, they have released my salary, then suddenly stopped my salary. I'm regularly attending the school. Even I have been 6/2, also I have been given that scope, and even I have been covered with NPS, everything. Only due to some material defects, that has been, they again stopped releasing my salary. And immediately I came with a legal notice under Section 8 at Annexure 10, page 54-56, Your Lordship. Annexure 10, my legal notice. And it was not completed 2 months period, they came with this impugn order. That is my submission before.
You are Miss Oza?
Yes. They came with the suspension order, Your Lordship, this impugn order.
Why did you file affidavit in opposition against your own writ petition? Tell me.
That was, yes, I have rectified, Your Lordship.
When?
Yes, it was filed on, that was as per direction of, yes, on 21/5/2005, Your Lordship. I filed as per the direction of the Honorable Court. I have rectified. There are some errors. I have rectified on
Where's your rectification?
21/5/2025, Your Lordship. I have filed.
Still very much there.
Rectification of this.
Yes, Ms. Das, what do you say?
Rectification copy has been served upon us.
How is it rectified?
Your Lordship, on the last
Cost title.
occasion, Your Lordship.
From the cost title?
Yes, Your
Yes,
Lordship.
there is only on the cost title, yes.
They have, she has mentioned it, Your Lordship, that.
It's not there.
Yes, it was in the last posted date, it was there in the file.
I can provide my copy, Your Lordship,
Let me see.
for the convenience.
Last posted date.
কেতিয়াবা misplace হৈ যায় record চাগে ধৰিব পৰা নাই
এইবিলাকেতো হৈ আছে ঘটনা
Oh, this is in the IA. I'm talking about the writ petition.
Yes, Your Lordship, this is in the
writ petitioner কথা কৈ আছে
a writ petition they have filed.
Please understand what I'm saying, then only you submit. You have filed affidavit.
I'm the writ petitioner, Your Lordship, here.
Please listen. You are the writ petitioner.
Yes, Your Lordship.
So why did you file affidavit in opposition against your own writ petition?
No, that is impleading. There is some clerical errors in the impleading. I have filed affidavit in opposition but there are some clerical errors only. It is that affidavit in opposition is filed in the interlocutory application, Your Lordship. But there are some clerical errors. Only the court has given me.
আপুনি fresh file কৰি দিয়ক নহ'ব
কৰিলো তো ক'ত গলি তো it was it
Madam, please show her this. See the red flag and explain.
মোক কপিটো দিবা দেই সেইপিনে দেখাও
Red flag, pink flag.
That is the arrear defective. I have rectified this.
Where is the rectification? That was what I'm asking you.
It was sorry. Good.
লাহেকে চাই
আচৰিত কথা নাই এইটো আগৰখনে Yeah, not irregular.
Oh, nice.
Nice.
It was not here, your lordship.
It is not there in second matter.
It is not in the
Not there.
record.
So that is why I'm asking you again and again.
File, your lordship.
This is there, Ms. Das. This copy of yours is there.
Yes,
Take
your
it back.
lordship.
This is regarding IA.
Regarding IA, your lordship.
Your lordship.
But in the writ petition, she has the writ petitioner
No, no,
same
no.
filing counter affidavit also against her own writ petition. I don't know why.
I rectified, your lordship.
It's just
It was কথা.
it's very unusual. Where's the rectification?
Wait, কথা.
I'll give you some more time to make the rectification.
Yes, I will. It was
On the
not.
prayer of Ms. M.A. Oja, learned counsel for the, just a minute, counsel for the petitioner. She is allowed to make necessary rectification in the affidavit of opposition, in the cause title. No, she's allowed to make necessary rectification in respect of, no, not regard, she's allowed to make necessary rectification in terms of order dated 14/5/2025.
14.
Okay, yes, please submit.
You file an impleading petition.
Yes,
That she has filed objection. Now that IA has come today.
correct.
So we may be allowed to be impleaded.
Let
So
us
we
see
have to
now.
say,
We'll argue, you argue on that.
because I was
First-
impleaded because my name is Manwara Begum in the page 57, your lordship has read. I was deprived from provincialization from my service. I am still serving.
Your
That's
lordship.
Okay,
Your
just a minute,
lordship. Your
just a minute,
Click to be impleaded. I
Your
cannot
lordship.
understand.
just a minute, just a minute.
Yes,
Now, just a minute,
regarding-
please listen. Insofar as the writ petition is concerned, you make the rectification.
Right.
All right,
Your lordship, I have filed on 21/5 and the document number is 1/2025. This is the acknowledgement.
it is not here in the file.
Yes. That
So you
is-
take up with the registry,
Yes, your
you
lordship.
take up with the filing section, make the rectification, okay?
This short time
So-
will be given, your lordship.
So for that purpose, matter ends there. Now let us come to the IA. What is this IA about? IA is also listed today.
Yes, I have given the copy also.
No.
1773 minute.
Hmm.
In that they have filed objection.
Yes, that objection is not, it was not tagged in the file, your lordship.
Yes, filed long ago.
So without that affidavit in opposition, I cannot assist your lordship because I have objected.
It is there.
Yes, your lordship.
It is there. What? Yes. It's available here. I'm talking about the IA.
Yes,
Now I is there.
IA is there. Objection is there. Are you not ready to argue on this IA?
Yes, I am ready.
Then writ petition, you correct it. This matter is already solved. But in the IA, Mr. Biswas wants to implead his client. You have filed an objection.
Yes,
So
that's
if,
not
so if both the parties are ready, it is tagged. It is here.
tagged.
yes,
That's
it's
it.
tagged.
Tagged. Oh, yes, your lordship.
And don't confuse.
Yes,
What correction is required in the writ petition for that affidavit. But in the IA, it is there.
yes, your lordship.
If parties are ready, you argue.
I clearly objected in my paragraph 5 of my objection, your
Let,
lordship.
let Mr. Biswas start first.
But I
He's
think
the
it is the
applicant.
right to be impleaded.
Why do you want, who's there?
Because my service, in page 57, you also find implead order, which is under challenge. There, my name, Manwara Begum, assistant teacher, was deprived of provincialization of her post as per the word, were given by the SMC.
Just a minute.
Whatever they have
Just a
done
minute,
with
Mr.
instrument, for which they were put under suspension. Headmaster and the.
Just a minute. See, both of you are very excited. I don't know.
No, I'm sorry.
I cannot hear such kind of excitement.
I'm sorry, but I'm.
You have to at least
Sure.
answer to the queries of the court. Court should understand your problem, then only we can solve it. But if you can sort of show your too much anxiousness, it becomes difficult. Please come to page 57 of the writ petition.
Yes.
You are saying that you are also there.
Yes.
What is your name?
Yes, Manwara Begum,
Manowara Begum.
assistant teacher. Additional.
Where is that?
Para 4. Whereas the district commissioner Dhubri is of the opinion that Manwara Begum, assistant teacher, additional was deprived of provincialization of her.
Para 4
Para 4.
of page 57
Oh, yes.
in the writ petition.
Yes. Of the post as per the word given by the SMC.
No, it's not like that. Are we on the same page?
Yes, yes.
Annexure?
1, 2, 3, 1, 4 line, my lord. Can you
And-
see? Top, 4 line.
In order to 57.
Okay. Then say 4 lines. Why do you say fourth paragraph?
4 line, I'm sorry. 4 line.
Okay. Read 4 lines.
So Manwara Begum, assistant teacher additional, was deprived of provincialization of her post as per the word given by the SMC to her father, late Sabed Ali, who donated the land for the establishing the building of the Motivator High School district Dhubri. Whereas the Mr. Muhammad Abdul Salam Sarkar, headmaster of the Motivator High School district Dhubri, manipulated the attendance register. See, very fun.
Okay. Okay. Now I got it, Mr.
Yes.
Mr. Biswas.
Yes.
You are for Manwara Begum.
Yes,
Correct.
madam. Yes, madam.
You want to implead her as respondent number
7.
7. Respondent number 7. Now you tell me, first of all, what is the prayer in the writ petition?
Prayer is for her payment of this salary for the period that she was suspension
And
as a LDA.
and also
And also, she said now she has that suspension withdrawn, madam.
Yes, your lordship, with that thing, your lordship, we have stated in our affidavit in opposition.
suspension withdrawn.
Yes.
Yes, your lordship.
Give me a copy of the order.
In their affidavit.
In our affidavit, your lordship, I
Annexed-
have annexed it as annexure 2, that is page 81.
In your affidavit of position,
Yes, your lordship.
file in the writ petition or on the IA.
No, your lordship, this is simple, filing the writ petition 2003/2024.
Page number?
Page 80 onwards, paragraph 5 onwards.
No, withdrawal of the
Yes,
suspension.
your lordship, that paragraph I have stated in paragraph 5.
No, show me the order.
Page, that is your lordship, annexure 2, your lordship, page 85. 84 on, annexure 1 is 84, then annexure 1A is 85. And annexure 2 is your lordship, page 87. Dated on 3rd October 2013.
An order.
That is on page 87. Annexure.
Plug it and show me.
Yes, like. একাল documents হৈছে খেলি মেলি হৈ থাকে naturally হ'ব
This one.
I'd
Please.
like to read it, your lordship.
Surely read.
Seen the interim order dated 16/5/2013 passed by Honorable Court in writ petition 2553/2013 that is filed by Mahmood Islam, Dhubri district, in compliance with the interim order passed by Honorable Court in the case, the provincialization order of Srimati Saira Khatun, Junior Assistant, which is stated in Respondent number 6 of Motichar HS Dhubri, which was issued by this office order under memo number so and so dated 38/2013 is hereby withdrawn till final disposal of the case.
So is that a withdrawal of the suspension?
Yes,
Tell
your
me.
lordship, that was your lordship.
You just read it's a withdrawal of the provincialization. We are talking about suspension.
And another is also your lordship, next page, your lordship, page 88. In partial modification onwards of this office order dated so and so, the order of suspension of Saira Khatun, LDA of Motichar High School is hereby cancelled, whose provincialization of service was withdrawn by this office order dated so and so, as per the interim order dated so and so, by the Honorable Court in writ petition 2553/2013, filed by Mahmudul Islam, till final disposal of the case, and subsequently terminated by the office order so and so dated 19/12/2014, based on report of District Scrutiny Committee Dhubri, as per the Honorable High Court order dated 30/5/2014, in writ petition 2553/2013. And moreover, Your Lordship, she did not stated, Your Lordship, page 82.
Your Lordship, Your Lordship.
Deprovincialization thing, Your Lordship, about her provincialization.
Okay.
She did not mention it, Your
Yes.
Lordship.
Your
Right.
Lordship.
Just a minute, just a minute.
It-
You'll get your turn. Listen. Now, claim in the writ petition is for subsistence allowance area salary, okay?
Yeah.
You have shown me a document by which her provincialization has been withdrawn.
Yes.
And later on, suspension also withdrawn. And she also has been terminated. What remains, isn't it? Nothing remains.
Yes.
And why,
No, the-
Mr. Biswas,
Yes.
please listen. In spite of all these things, why you still want to implead yourself?
Because she is claiming subsistence allowance of her that period, which she is not entitled.
And also, Your Lordship, I have stated.
No, but who are you?
Well,
Who are you?
I could praise the entire matter.
Who are
because I
you?
was one of the victims.
You are the victim. Maybe you fight out in that section 5041 before the tribunal.
Therefore-
Somebody is claiming subsistence allowance,
Yes.
and at the same time, from the affidavit of the government,
Yes.
everything is gone.
She's no more in.
Listen, please listen. She's no more in service.
And also.
So you have to just say that you don't have to be impleaded a writ petition which is having a natural death.
Problem.
You want to implead yourself in that writ petition for what? Just to show your name.
No, I don't want.
No
to be
purpose.
In a died.
Now let me get back to Madam
Yes,
Petitioner.
Your Lordship.
You have received a copy of this
Couldn't be done.
affidavit? No. These are a part of the writ petition itself, isn't it?
Your Lordship.
Deprovincialization of কোথায়?
Deprovincialization. No, this is from the affidavit in opposition.
Affidavit in opposition.
Have you received a copy of the affidavit in opposition?
Yes.
You have received, okay. Now please come to page 87. Order dated 3rd October 2013. Your provincialization gone. Next page, order dated 2/4/2024.
Yes.
Your
This-
suspension also withdrawn.
Yes, Your Lordship. This
Now,
is-
just listen.
Yes, Lord.
And page 89, you are also terminated.
Yes, I am terminated. I have
So what remains
edited
now?
Here, this corrigendum.
And you yourself say that you have gone to the
Yes, these are the,
tribunal under section 41.
Your Lordship, these are
Go and
the,
raise your point there.
yes,
there's nothing-
I am raising. Then thereafter, they have again reinstate me and releasing my salary. That is
Where?
after disposal of Your Lordship, kindly come to,
Where's your reinstatement?
they have releasing, I have stated in my,
No,
Read
forget about the
this-
statement. Give me the order. Your reinstatement.
there is no,
Then?
they have releasing my salary.
How? Where?
They're releasing my salary.
When?
I have stated in my petition, Your Lordship, read petition
Where's that?
at
Paragraph number?
paragraph, Your Lordship, 9. At 9, Your Lordship. That a may I be pleased to read over at page 11. Please, Your Lordship, come to paragraph 8 first, Your Lordship. May I be pleased to read over?
Yes, paragraph 8.
Paragraph 8, may I be pleased to read over?
Yes.
That the petitioner begs to state that thereafter the petitioner had approached the Education Tribunal, Dhubri, on 18/12/2018, bent upon miscellaneous education case number 5 of 2018, that is Saira Khatun versus the state of Assam, and the respondents had filed their written statement on 8/3/2019 and 26/4/2019 respectively, whereby reflected therein the existence in bracket continuation of the petitioner as LDA junior assistant in the school, that is Motisar High School, from the date of appointment on 11/12/2001 and joining on 12/12/2001 of the petitioner, and her services had brought under provincialization scheme with effect from 1/1/2013 by the respondents. This has been given effect to after thoroughly scrutinize the particulars of the teaching and non-teaching staff submitted by the school authority, by the district scrutiny committee, Dhuburi, as per law. It is pertinent to mention herein that it is seen affirmative in the affidavit of the respondents during the pendency of the case before the educational tribunal. Both the parties are agreed to settle the issue amicably after submitted no objection by the respondents, and it was done as per the order 23 Rule 3 Roman 1. So far, the compromise relates to the subject matter of the suit. That point was already noted earlier. The case is disposed of on withdrawal on 22/12/2022 and allowed the petition of the petitioner.
Your case has been disposed of.
There, in tribunal, first, immediate after this honorable court's order, I have approached only myself. There are other 5 litigants, and
No, your case, which is this? Miscellaneous education case number 5/2018 has been disposed of.
yes, your lordship.
So you produce the order as well as the written statement.
Annexure 9, your lordship. Annexure 9, page 53.
Then where is the written statement?
It is here. It is in loose only, your lordship. I can submit before your lordship.
File it by way of an affidavit,
Yes, your lordship.
because you have
Yes.
stated so many things.
Because the district scrutiny committee has affirmed in my favor in the written statement as well as in the even the states. So there is nothing left out here in the tribunal. And this Manora Begum, the interlocutor applicant, has come first time for the in 2023, your lordship. Just I am within my limitation, I would brought before your lordship notice that the same sets of fact, it is lingering from 2013. She never approached this honorable court. This is for the first time when my impugn order, the suspension order was passed based on the inquiry report. And that inquiry report was also totally vague, your lordship, because the vital, those FSL report, because my appointment was dubious only for some manipulation, as alleged by them, the state respondents. But in the inquiry report, those vital documents, when they came to finality, they have not inserted those vital documents like FSL report, the final report. These are not inserted in the, it is not reflected in the inquiry. Everything I have again placed before the honorable tribunal, your lordship. Immediate when, after completion of 2 months period of the notice under section 80. So these are the facts. These are very crucial aspect, not only for me, for the entire school, your lordship.
See, like I said, you have been terminated.
Yes, your lordship.
Then you say you're still working.
Yes, because they have released my salary till May 2023, your lordship.
Where's that? Show me.
Yes, I have stated here only.
Where?
Paragraph 9. Paragraph 9 at page 11. Paragraph 9, your lordship.
May
But bills
2020.
has not been annexed, your lordship.
Hmm?
Bills has not been annexed, your lordship. It was
Yes, I
simply
will,
stated.
yes,
it,
I will
your
annex,
lordship.
if your lordship permit me to file my additional affidavit.
Okay, you file it, okay?
Will-
You file it because
Yes, your lordship.
difficult, because
In my custody now.
in a writ petition, we'll have to decide matters by way of an affidavit. We cannot take evidence and all that.
Here,
So you file the documents by way of an additional affidavit within a week's time.
your lordship may kindly be fixed in a very short date may be given. It is available in my custody, your lordship.
We'll have it immediately after the opening. Please write, In the writ petition, okay, in the writ petition. It is further noticed that although the secondary education department has annexed documents in the counter affidavit showing that the provincialization of the petitioner has been withdrawn by order dated 3/10/2013. The suspension of the petitioner has been withdrawn and her service itself has been terminated by order dated 19/12/2014 with effect from 3/10/2013. The petitioner in paragraph number 9 of the writ petition has stated that she has received her salary till May 2023 and the same has been stopped from June 2023. Since there appears to be some contradiction in the documents filed by the petitioner and the statement made by the petitioner shall file an additional affidavit incorporating the documents to show that she has indeed received salary till May 2023. Let such additional affidavit be filed within 10 days from today. List the matter again, so and so. 21/7.
Master, please.
Along with the IA. 21/7. I'll just rise for 5 minutes and come back. This is item number.
In this matter, we have challenged the appointment of the private respondent.
Just a minute. Have you checked the office note?
Yes, as per note 15,
13 and 14.
it may be stuck of one.
Please write down office note dated 11/6/2025 indicates that upon tracking of the postal consignment, notice appears to have been delivered to the respondent numbers 13 and 14. So further, the learned counsel for the petitioner has prayed for deleting the name of respondent number 15. Stop next para. In view of above, notice is accepted to be complete on respondent numbers 13 and 14. Stop. Why do you want deletion of this respondent?
So he did not join, madam. I have challenged the appointment of the private respondents. The 15
Okay.
did not join, so.
Then stop as
there's
prayed
no
for.
vacancy.
Respondent number, the name of respondent number 15 also stands deleted from the arrayed respondents. Okay, now you tell me what is to be done.
And the service in respect of other respondents, my lord, 8 to 12. It is not yet completed.
When were steps taken?
We have taken steps
When?
immediately after issuance of the notice, my lord.
See, I don't think it was immediately. That's why it went to the Lauzima court.
For the Lauzima court, only in respect of 15.
No. So it's a long time now. I think it's.
There's an order of the Lauzima court dated 9/5. But it reflects that service in respect of 9, 10, 11, 12 is incomplete. 9/5.
14 is already represented by somebody. There's a counsel. Respondent number 14.
Respondent number.
Wow.
I have not joined, Lordship. My learned friend has already paid for striking out of my name, Lordship. I have not joined.
Striking out name is 15.
My lord, 14 may also be deleted if since
14.
Then you cancel the order. This is not a correct order. The Lauzima court's order dated 11/6/2025 indicates that notice has been served to respondent number 13 and 14. As per postal track report, to stop, the petitioner has also played for deletion of the name of respondent number 15. To stop, today, Mr. M. Ahmed, Learned Counsel, appearing for respondent number 14, submits that respondent number 14 has not joined the post, and therefore his name also may be struck off. Next para, in view of above, notice on respondent number 13 is accepted to be complete. Stop, the name of respondent numbers 14 and 15 be struck off from the arrayed respondents. Now, who else remains now?
9/5/2025, your lordship, kindly see the Lauzima court's order. 8, 9, 10, 11, 12, service is complete. 9/5/2025.
So 13, 14 we have taken care of already.
Yes.
What remains is 8, isn't it?
8, 9, 10, 11, 12. This order says that 8, 9, 10, 11, 12 completed.
Where's that?
No, 8 has been completed.
13 to 13.
In the middle portion, my lord. Respondent number 8.
8, 9, 10, 11 and 12.
9,
So-
10, 11, 12, it is awaited.
No. Lauzima court's order dated 9/5/25.
Yes, all are completed.
It says 9 to 12 is complete.
Complete.
8 also complete.
Yes.
Then who remains?
13
13 is less, I think.
13 also complete.
Complete.
13?
13 also complete. I just passed the order.
Okay.
How many respondents are there in all?
8 to 15 were there. 7 respondents and 2 have been deleted. 8, 9, 10.
7 is board.
7 is board one.
No, sir, I am for 1 and 4, no, sir, 1 to 4. So high risk, no, sir, technical, 1 to 4. Yes, Bhuya.
1 to 4, Lordship. Mr. Harding.
I am for respondent number 6, A Burwa.
I'm for respondent number 5, Your Lordship, RM Barwa.
A Burwa.
6, 7 or pariboni. Engineering is board of and learner can be here perhaps. You can mean board. You think advertise should go.
No, it's a textile institute, Lordship.
No, it's a address to textile.
Engineering.
Engineering recruitment board.
Board is an board.
That is the address.
Campus, so yes, yes, so you can.
Probably listed as admission.
Obliged, Lordship.
Obliged.
Maybe the Lordship. Lordship, this is I for correction of the name, Lordship. Lordship, kindly see the order dated. Lordship,
Page number?
14, Lordship, page 8, Lordship. Lordship, this is typical mistake. This was typical mistake, Lordship.
Page 8?
Yes.
Which paragraph?
Lordship, this is actually post title in the order, Lordship.
Hmm?
In the post title, Lordship, late Mukhtar Hussain, Lordship, kindly see page 8.
Hmm.
Actually, this is actually the husband of the petitioner, Mukhtar Hussain, Lordship. He was
No, which one is not
alive,
correct? Where is the typing mistake?
late Lordship.
Where? Wife of late
Yes, Mukhtar Hussain, Lordship. He is still alive, Lordship.
Oh, late should not be there.
Yes, Lordship.
Any other mistake?
No, Lordship.
At affidavit also it is wrong. You typed as late. Affidavit
It
also.
was in the
From CIS. Give me the writ petition.
Yeah.
Somebody has used the correcting fluid. Hmm. Any objection? Writ petition was disposed of, isn't it? See, original typing.
Yes, Lordship.
The original typing in your writ petition.
Yes, Lordship.
Cost title as well as affidavit. Late is there.
Yes, Lordship.
And somebody corrected by correcting fluid. Who has done it?
During the filing section, filing time, Lordship. Some that may be.
Who has done it? You have done it.
Lordship, my clerk.
So
This is one of
that should have been informed. That's why it appeared as late.
Otherwise, Lordship, it is based on the wrong affidavit, Lordship.
No.
Wrong affidavit?
Yes, Lordship, it was also affidavit also there is late was found, Lordship. That for correction for that correction, Lordship, they have to file one IA, Lordship, for that correction. They are not filing that IA. No, it was after disposal of the writ petition. During the pendency, you should have filed.
It is stamped after passing the order. In the post title. So,
Heard, Mr.
yes, Islam, Lordship.
S. Islam, learned counsel for the applicant, who submits that by filing this application, the applicant seeks for correction of the typographical mistake appearing against the name of Mukhtar Hussain who is the husband of Afina Khatun, the applicant. Afina or Albina?
Afina, A-F-I-N-A.
Okay. Learned counsel for the respondent, Miss
Esquire.
S. Kaur, submits that the same may not be a typing mistake in view of the fact that in the affidavit filed in the writ petition,
Yes.
it has been indicated as late Mokhtar Hussain. To stop in the copy of this court, it is also seen that in the cause title as well as in the affidavit, the word late has been erased by using correcting fluid. To stop. Therefore, the applicant ought to have sought for correction during the pendency of the writ petition. Stop. Now, be that as it may, for the ends of justice, court is inclined to allow the application for deleting the word late appearing against the name of Mokhtar Hussain. In view of above, writ petition stands the application stands disposed of as allowed, as prayed for.
I'm deeply obliged.
Orders or motion. Let us finish the motion.
Standing item 4.
Yes, Mr. Sheikh.
Not, here in this case, my lord. My lord, I'm drawing your lordship attention. Page 63 onwards, my lord, 11 portion 66.
Yes, what is it?
So, my lord, the matter is regarding compassionate appointment, my lord. That lastly, my lord, your lordship.
This is second round.
Page second 66, my lord.
Second round.
Yes, my lord.
Okay.
So 66, my lord, your lordship, after considering my writ petition, para 8, accordingly, matter is again remanded back to the DLC, Sirang district, to reconsider the case of the petitioner in terms of clause 15 of the OM dated 1/6/2015 and commensurate to her education qualification, and thereafter make its recommendation in its next immediate sitting. Any decision taken of the DLC shall be communicated to the petitioner forthwith. But that was not done. That was the grievance of the petitioner before your lordship, and your lordship was pleased to that the BTC council, my lord, on 12 24/4/25, my lord, taken time to obtain instruction whether this has been carried out or not. And that is placed before the next meeting or not. That is a short campus, my lord.
Yes.
Lordship, we'd like to file our affidavit. Lordship, we've received our instructions.
What is the instruction?
Lordship, the DLC has again rejected the claim of the petitioner because, Lordship, two similar petitions were filed by the same person praying for the same thing for compassionate appointment. And it was rejected on the ground of delay in submission of application by the petitioner, as well as lack of vacant posts of in grade 4, Lordship. And the petitioner also does not qualify to be appointed under compassionate family scheme.
Why?
Lordship, due to late submission of the application, first of all, and secondly, Lordship, two similar petitions were disposed of on the same ground, wherein DLC again rejected the claim of the petitioner, Lordship.
So if the DLC rejected means they accepted. Where's the question of they're being late, delayed?
Lordship, there was a delay of 3 months in filing the application. That was also
Despite
considered
that-
as a ground,
Despite that, you entertained it
Lordship.
and you rejected it, isn't it?
Lordship.
So where's the question of raising the delay issue now?
Lordship, it was first.
If you felt that there was delay, then you don't entertain at all, reject it. But it seems you entertained it and then you rejected it. But that's another thing. One more thing is that why didn't you communicate it to the petitioner? According to the petitioner, he or she does not know what has happened. That is why they have come again before this court. You should have communicated. And what is clause 15? Clause 15 is that if there's no vacancy in one department, you may go for other department also, if there is vacancy. Isn't it? So the instruction which you just read out, does it say like that?
No, Lordship.
That we have inquired from all departments, there is no vacancy anywhere. Then
Lordship, we may be allowed to bring this into record by filing an affidavit.
you'll bring, but again, the same question will be asked to you. You try to find out. Heard Mr. M.A. Sheikh, learned counsel for the petitioner, who submits that despite direction passed by this court on 21/7/2023 for reconsidering the case of the petitioner in terms of clause 15 of the OM dated 1/6/2015, the same has not been done, prompting the petitioner to come again before this court through the instant writ petition. Your good name, full stop.
A. Borthakur for P. Nayak.
Ms. A. Borthakur, learned counsel appearing for Mr. P. Naik, standing counsel BTC, submits that she has received the instructions, which is to the effect that the case of the petitioner was indeed considered despite delay, and that the DLC had again rejected his application. Full stop. She submits that she may be allowed to file the same by open affidavit. Full stop. It may be seen that the order of this court was to consider the case of the petitioner in terms of clause 15 of OM dated 1/6/2015. And therefore, the affidavit to be filed should indicate as to whether the case of the petitioner has been indeed considered as per clause 15. List again after the ensuing summer vacation on a date to be fixed by the registry.
Highly opposed.
The date is fixed, my lord.
Date will be fixed. The registry will do it, okay?
My lord. My lord, here in this case, my lord, a very short prayer before your lordship. That my service was, first I was appointed in 93, my lord. So thereafter, my lord, my service was time to time extended. Ultimately, my lord, service was regularized in later stage, my lord. So, my lord, service was regularized on 33/96. But from 93, I continued in service. So, my lord, my grievance is this, my lord. And thereafter, my lord, I came before your lordship times and again for arrear salary. And ultimately, your lordship rejected that. Now, my lord, my grievance is this, my lord, that the pensionary benefit may be given, calculated from 23/11/93 as I was in continuous service. That is the point, my lord, and to that extent, my lord, I have filed a representation at page 23. Now, my lord, at present, I pray before your lordship that that representation may be disposed of by a speaking order.
Which
with a copy to
representation?
me, page 23, my lord.
23.
That is the short prayer, my lord. Because let the department decide whether I am entitled to pension, pensionary and other service benefit from 23/11/93 or from the date of regularization. That is the point to be decided by the authority. And that, to that extent is the representation at page 23, ma'am.
You were working as what, music teacher?
Yes, ma'am.
How many years?
Music teacher, and my service was regularized, ma'am. My service subsequently regularized with effect from, my lord, 33/303/96.
And you entered service on ad hoc basis
My lord, on ad hoc basis
in
from
1993.
93 to 96. Now, my lord,
So-
there is a office memorandum.
So you served for how many? 3 years?
My lord, 3 years, 93 to 96, my lord, 3 years on ad hoc basis. Thereafter, my lord, I am continuing from 96 till date.
Till date?
Yes, ma'am.
You're still serving?
Yes, I am serving. As
You're
regular-
serving till date?
Regular teacher, my lord. And going to retire. Retire 50 years, 58 years, no? 2 years. 2 years service is there, my lord.
When are you going to retire?
My lord, I am going to retire. Now I am 58, my lord, by 27 like this, man.
Your presentation is before director.
Yes, my lord.
What do you say, Mr. Chisti?
Lordship may kindly give us some time to get the instruction before disposing it on the first day, Lordship. Lordship may kindly issue notice immediately on reopening date, Lordship may kindly fix. On that day, if you Lordship satisfied, Lordship may kindly dispose it of.
Mr. Sheikh?
On the first day we reopening, Lordship may kindly
My
fix.
lord, actually, it was on 9/5/2025. My lord, 9/5/2025. Your lordship granted 2 weeks time to obtain instruction.
They want some more time.
My lord.
Anyway, Lordship, yes.
Maybe, my lord, only thing is this, my lord, I'm going to retire because, my lord, without
2 years is
getting
there.
a representation, I.
Yes.
2 years is there, it's a long
27
time is
years.
there. Yes, notice should go at this stage on the.
What happened before 27?
On immediate reopening date.
My lord, only thing
Okay.
is this, my lord, I humbly
Mr. M.S. Sheikh,
and
Lord,
submit
Mr.
before
Before
your
the
lordship. On the
Mr.
first
Mr.
day,
teaches
they
current
ask
and
for
for
the
senior
instruction.
education.
It is
Place
killing of
for the
time,
time
my lord, only.
to obtain instructions. Accordingly, list again on so and so. 18/7. Let him come with instructions,
Yes.
we'll see.
18/7, oblige, your lordship.
Yes. Petitioners were initially appointed as Hindi language teachers in the ME schools, which were in venture stage. ME schools means upper primary, starting from class 5 to class 8. The schools were at venture stage. They were appointed. I have given a tabular chart at page number 15 showing their date of appointment, the schools, and the length of their service. Now, Lordship, their appointment was also duly approved by the district elementary education officers, and they were serving for some 20 years, 25 years. And Lordship knows that in ME schools or in upper primary schools, Hindi is a compulsory subject. Under the old act of 2011, your Lordship, Hindi teachers were compulsorily provincialized under the old act. And many schools, upper primary schools were provincialized under the old act. Unfortunately, the schools of the petitioners were left out. Now, in 2017, Lordship, when the new act came big and the process for provincialization started, your Lordship, these petitioners who are serving as Hindi language teachers, their service have not been provincialized while other teachers were provincialized. Hindi being a compulsory language, your Lordship, it requires to be provincialized. And
You're working as on day?
Lordship.
You're still working?
We are going, but our signature not being taken because after provincialization, only 3 teachers have been provincialized. We are going till today, your Lordship. We are.
You're working since when?
Lordship, different, at page number 15, Lordship, may see.
There are more than one petitioner.
More than one petitioner. So I have given a tabular chart, your Lordship, date of appointment and the length of service.
Paragraph number 2.
Lordship, some 15 years, some 31 years,
Oh, there's quite a lot of them.
Lordship.
How many of them in all? 74.
Lordship. Lordship. Now, under section 3(1)(11), your Lordship, there is a provision that for additional posts, it can be considered in accordance with Arrear. And in that line, your Lordship, similar matters have been disposed of also. I have annexed the orders also. Case is that they were Hindi teachers, your Lordship. Hindi is a compulsory subject. And without proper knowledge of Hindi, no one else can teach Hindi also. they have the requisite qualifications also. But during the provincialization, your lordship, the post of Hindi teachers, their posts have not been provincialized.
Why is that? There must be some reason.
Lordship. Lordship will find one order at page number 150, your lordships. In similar matters, this court has disposed of, your lordship, directing that it should be reconsidered in terms of section 3111 of the Act. In that line, it can also be disposed of, or lordship may also notice.
No, in this case, notice should go on lordship at this stage. This is not a case to be disposed of on the first day.
Since there are similar orders, therefore,
Even then, lordship.
Lordship, in this matter, we'll be filing a consolidated affidavit in opposition, since it's a motion matter, my lord. Lordship will
Okay, heard,
notice for the timing.
heard Mr.
MH Laskar.
M.H. Lashkar, learned counsel for the petitioners, who submits that having common grievance, the petitioners who are 74 in numbers have joined hands and filed the instant writ petition. He submits that the petitioners were appointed as Hindi language teachers in various upper primary (ME) schools, which were established as venture schools in Lakhimpur district, Assam, who stopped having served continuously for more than 20 years. The petitioners are still continuing without any fixed pay, with the hope that their service will be provincialized. Gustav, the learned counsel submits that Hindi language being a compulsory subject taught in the ME schools in the state of Assam, the services of the petitioners are very much required in the schools. Next, in view of above issue notice of motion returnable by 4 weeks, Mr. A. Fukar, learned standing counsel.
Lordship, I'm appearing for 1, 2, 4, and 5.
Elementary Education Department. Access notice on behalf of respondent numbers 1, 2, 4, and 5.
1, 2, 4, and 5, my lord. And my lord, Lordship will record Mr. B. Diori's name for respondent number 3, my lord.
Mr. B. Diori, learned counsel, appears for respondent number 3. Gustav, as such notice is complete, petitioner to serve requisite extra copies. The learned counsel is appearing today within 3 working days. This again after 4 weeks.
Obliged, Lordship. Deeply obliged.
Admission at 14.
I think 15. 1, 5.
Well, in this case, my lord, second time litigation to come to the 2017 matter, my lord. And there is a specific direction by order dated 12 to 2024, my lordship. Order dated 12 to 2024, my lord.
What thing? Please come again.
Yeah, my lord, 12 to 2024.
Yes, some order was passed. What
Yes,
is this?
yes. This court on 4/8/2021 directed the Learned Standing Council for the Elementary Education Department to place the information instruction in form of affidavit in view of submission made by the Learned Standing Council for the Elementary Education Department that the petitioner on 2 occasions had made 2 different statements before the inquiry committee, for which a final decision yet to be taken. It is astonishing to note that even after lapse of more than 2 years, the Learned Standing Council for the Elementary Education Department is yet to receive the instruction. Be that as it may, let this matter be listed after 2 weeks so as to enable the Learned Standing Council for the Elementary Education Department to place the information instruction with regard to the final decision of the government in the form of affidavit as directed by this court supra. It is made clear that no further adjournment shall be granted to the Learned Standing Council for the Elementary Education Department on next date fees. And today's matter is listed. Matter is, my lord, the stipendiary teacher man initially, and has received till March 2006, and thereafter she was transferred to another place. Thereafter her salary was stopped, and she came before the honorable court. Please may kindly see the order dated page 22, my lord. Page 22. My lord, total 7 petitioner, my serial number is 6, page 24. And honorable court by order dated 21/8/2009 and operative portion page 28. Last paragraph. In view of the above agreement in bar, this case is disposed of by directing the petitioner to make an appropriate representation before the district elementary education officer, who will take a requisite steps within 3 weeks thereafter for referring the claim of the petitioner before the aforesaid committee. For the purpose of this, petitioner would furnish a copy of the order along with a writ petition so Director Elementary Education Assam and DO Lakhimpur for taking appropriate steps. And thereafter notice was issued, my lord, page 29, my lord. Petitioner called by the District Elementary Education Officer, page 29. It is hereby inform you that on 19/12/2014, Friday, your appointment and service related documents will be verified at the below mentioned venue and time. Therefore, you are hereby informed to refrain the present along with below mentioned documents on the said date to the concerned place, my lord. And thereafter, my lord, page 32. Page 32, my lord, the report of verification was submitted, my lord, but not on petitioner, my lord, as a whole of the entire state of Assam, my lord. Appointments were made without so appointment authority. Thereafter, my lord, they file an affidavit, my lord. Your lordship go through it, my lord. Para 7, my lord. Affidavit filed by the director, my lord. Director Elementary Education, para 7, my lord. May I read, my lord? Your lordship got it, my lord? Affidavit apposition filed by the Director Elementary Education on May 2017. Para 7. You got it, my lord.
Counter affidavit?
Yes, my lord. Counter affidavit filed by the
Director
Elementary
Respond
Education.
number 2, my lord.
Respond number 2, my lord. Para 7, my lord. The deep. Your lordship got it, my lord?
Paragraph?
Paragraph 7, my lord. Your lordship.
Just read.
That the deponent begs to state that in the meantime, the government has constituted a scanning committee to look into the irregularly appointed teacher during 91 to 2001 throughout the state of Assam, and in this regard, Director had issued advertisements so invited application for such category teacher. It is stated that those who had responded pursuant to advertisement dated 2012, their case were examined by the preliminary scanning committee. It is to be noted that the name of the petitioner appeared at serial number 07522 in the state list of irregular illegal teacher appointed during the period of 91 to 2001. The state, and after preliminary scanning of the application throughout the state, the report has been sent to the government. Thereafter, government had filed further constituted divisional scanning committee by notification 6/4/2014 to examine the report. Preliminary scanning committee. The irregularity illegal appointed teacher were also asked to appear before the scanning committee for verification of their particular ascertained genuineness of the appointment. The case of the petitioner, along with others, were verified by the divisional scanning committee, North Assam Division, Tezpur, and committee had furnished its report to the government for consideration. And para 8, my lord, last liner, the re-verification report will be examined for taking final decision on the matter, which is under process at government level. It is stated the government has not yet taken any decision on the scanning box. And thereafter, pursuant to the affidavit in opposition, Honorable Court directed the what action has been taken, what is the report. Because of that, this issue was appeared before the authority pursuant to the Honorable High Court's order. And my lord, all similar situated persons, all are now same select list, my lord. I have also select list, my lord. They are receiving salary due to my transfer to the one place to another. My salary was stopped, my lord, and she is suffering lots.
Mr. Fukan, what do you say?
Lordship, in this matter, see, though we have filed an affidavit, my lord, regarding the up-to-date status of the, my lord, instruction which was last sought for, my lord, I am awaiting that, my lord. So I have been instructed by the department to, my lord, take some time, my lord. In the meantime, my lord, if your lordship fixes a date, my lord, immediately after the vacation, I will bring that on record, because I think that will be crucial for the proper adjudication of the case,
Well, it is made clear by this honorable court last occasion on 12 to 2024. It
My
is
lord,
made clear that no further
My lord, I
adjournment shall be
understand, my lord.
granted.
What has happened was, my lord, at that point of time,
And
the
my lord,
court was
what
not
is the
aware-
communication
the-
they sent?
the
They may
court-
be produced, my lord.
My lord, the court is not aware that time, my lord. What happened was there was a confusion regarding the writ petition, my lord. The copy was not sent, my lord. So we again clarified that. So there was some misplacement, my lord. So they have therefore requested us, my lord, that some time may be given.
Whether standing council communicated to the authority or not, that may be also verified because of so many times they take time. She is suffering a lot, my lord. And others, some of the
My lord,
irregular
lordship
teachers,
goes by the
they
record.
were appointed a tutor, but that lady was also not
My
there
lord,
doing it.
technically, my lord, we have already filed an affidavit, if your lordship sees.
Oh,
It's not
on the
that
basis of
we have been diligent. That enough to file an affidavit. It's not that we have not filed any affidavit. So one time chance can be given, my lord. My lord, the petitioner council is being a little more harsh, my lord, because we have already filed an affidavit. Just we need the instructions, my lord, to basically.
Okay,
support
after
us.
the vacation, huh?
My lord,
Mr. F. Fukan, Learned Counsel for the Elementary Education Department, place for is granted further 3 weeks time to obtain complete instructions in the matter. List again on swell.
as a last chance, my lord.
Deeply obliged.
His name may be recorded, but that day or other councils are coming, my lord. They are doing that same.
Lordship will record my name if required.
His name may be recorded.
If he wants so much.
Yes, my lord.
I'll be here, man. I'll be here. I'll note down, man. I'll be here. Deeply obliged.
So we'll come back at 2.
How
many matters left? Sure. Should we take?
See, this number to time long. কি করবো? কোন জায়গা হবে? কোন জায়গা? কোন কলেজে? মই গেলে কম মই।
স্কুল তো মানে না?
মোৰ চাই থাকে।
My lord, item 20 also same, my lord, after vacation may be taken. The last date on the instruction was sought for, my lord. That instruction is here, item 20. The same council. 20.
That 20, my lord. They're also.
My learning 20 separate. Okay. GPay. Yes.
Fix it there, man. Man.
Obliged.
Much obliged.
Upon due consideration of the case in its entirety, the impugn order of conviction and the order of sentence are found to be not sustainable, and accordingly they are set aside. The appellant is directed to be released if not wanted in connection with any other case. With the above observation and direction, the appeal stands disposed of as allowed. Registry is directed to send back the trial court records immediately.
Deeply obliged, my lord.
Production date, item 1.
May I please, Your Lordship? Your Lordship, in this matter, the connected date petition is disposed of, Your Lordship. The matter pertains to compassionate appointment. The father of the petitioner and the applicant.
What is this IA for?
IA for impleadment of the party, Your Lordship. The wrongly parties were arrayed as respondent number 1, 4, and 6 in the connected date.
Isn't that a bit too late now?
Your Lordship, he was recommended by DLC.
How do you erase somebody after the petition is disposed of? How was it disposed of, the petition?
The petition was allowed, Your Lordship.
Regarding compassionate appointment.
Compassionate appointment. He was recommended by PHE, Your Lordship.
What was the direction?
Direction is page number 17, Your Lordship. Onwards. Para 7.
Yeah, I think I should be listed before the appropriate bench. I don't know the facts of the case. Perhaps if it can come up before the concerned bench.
As Your Lordship.
Hmm.
Otherwise, Your Lordship,
This is the matter before the appropriate bench.
Obliged.
Make it below. But this review against the order dated 28/20/2021. Lordship will find at page 59.
Page 59.
Page 59. Order starts from page 60.
What is the matter regarding?
Regarding the provincialization, Willow.
And there's a dispute between the petitioner and the writ petitioner and the private respondent.
Initially, in the earlier round of litigation, there was a dispute between the petitioner and the private respondent.
How many rounds?
The earlier there was a writ petition 533/2012.
Filed by?
Filed by
Same.
Filed by the petitioner. Yes.
Same writ petitioner.
Same writ petitioner.
What is the case number?
533/2012.
533.
Oh, sorry. It was filed by the respondent number 7.
Number?
Respondent number 7.
File number? I mean, writ petition number?
Writ petition number 533/2012.
Then second one?
Second one is 462/2020.
462.
Yes.
2020.
2020.
By the review petitioner.
No, review is filed by the state member.
Oh, reviews by the state.
State.
So first of all, respondent number 7 files a different one.
My lord.
First writ petition, then the writ petitioner files 462.
462.
And which was disposed of on?
Disposed on 28/10/2021.
28/10.
10/2021.
So it's against this that you've sought review.
Yes, ma'am.
Okay.
May I just read the order first?
Yes.
First paragraph I'm skipping from 2. The petitioner claims to have been appointed as assistant teacher in the Jungle Block High School in the Nagaon district as per resolution number 3
of the Managing Committee dated 30/11/1997. While the claim of the petitioner of the Jungle Block High School was considered for provincialization under the Assam Venture Education Institute Provincialization of Services Act 2011, in short, Act of 2011, one Abdul Khalik, who was a science graduate with zoology, geography,
Just a
and
minute,
mathematics.
Mr. Kaushik.
Man.
Yes.
Malik, who was a science graduate with zoology, geography, and mathematics, was provincialized as the first assistant teacher. The petitioner claimed that she had a legal right to have been provincialized under the Act of 2011 as a second assistant teacher in the science of the school. The respondent number 7, Muhammad Ahmad Ali Talukdar, instituted WPC number 533/2012, claiming his right to be provincialized as a second assistant teacher science. And in said petition, there was an interim order dated 15/11/2012 restraining the provincialization of the second assistant teacher science. During the pendency of 533/2012, the respondent number 4, being the Director of Secondary Education Assam, by the order dated 22/9/2014, had provincialized the services of all other teaching and non-teaching staff of the Jungle Block High School by keeping the second post of the assistant teacher sign vacant for provincialization. WPC 533/2012 was given a final consideration by order dated 23/11/2015 with a direction to the District Level Scrutiny Committee in Score, DLSC, to examine the claim of the respondent number 7. The DLC, upon examination, arrived at its conclusion that the writ petitioner, Marjan Begum, is senior to Muhammad Ahmad Ali Talukdar and therefore would be entitled for provincialization. The writ petition is instituted and nothing further has been done, and the recommendation of the DLC made in favor of the petitioner had not been acted upon. Your Lordship will kindly mark this line.
No, Marjan Begum is the petitioner in
Is the
42.
petitioner of that petition. Now, basic grievance of the petitioner was that the DLC has recommended the petitioners for provincialization and nothing was happened thereafter. My Lord finds that line. The writ petition is instituted that nothing further has been done, and the recommendation of the DLSC made in favor of the petitioner had not been acted upon.
DLC upon examination arrived at the conclusion that Marjan Begum
My Lord, yes.
therefore would be entitled for provincialization.
Lordship is reading para 4.
Yes.
Yes. Para 4, last line, my Lord. It
Hmm.
starts from this writ petition is instituted.
So that respondent number 7's writ petition was disposed of.
Was disposed of.
For examination.
For examination.
Then examination result was that Marjan Begum is senior.
Senior, yes.
Then nothing was done.
Nothing was done.
Hmm.
Well, basically, the grievance of the petitioner was that DLC has recommended. Well, that is where I have sought for a review. There was no recommendation by the DLC made in favor of the petitioner, madam.
There are no documents.
No.
Then how come this observation came?
My Lord, may I just read further, my Lord? I'll then come to that.
Okay.
Considering the limited grievances raised, we disposed of the writ petition, directing the Director of Secondary Education to bring the recommendation of the DLSC made in favor of the petitioner to its logical end by passing an appropriate order. Now this also is very important, my Lord, as it is a case of deemed provincialization under Section 4(1) Act of 2011. In the event the authorities are of the view that the petitioner satisfies all requirement of Section 3, which in fact would be as because the DLC had examined the matter and recommended in favor, the benefits of provincialization be made applicable from 1/1/2013 as provided under the Act of 2011.
What does the Act provide? Section 3?
Section 3 are the eligible criteria for provincialization. Now,
the Act says that whoever is found eligible will get the effective date from 1/1/2013.
Section 4 confers that.
4 or 3?
Section 3 are the eligible criteria for selection of the educational institutions or bringing within the purview of provincialization. Now, once the school is found to be eligible under Section 3, that is, the teachers of that school would be provincialized under Section 4, and the effect of provincialization is from the date of the Act came into force in 1/1/2013.
Okay, so what I understand now is that both the writ petitioners claim they are entitled for provincialization
Provincialization.
as science teacher.
Science teacher.
What the authorities have done is that provincialize everybody except for the science teacher,
Except-
was
except
the vacant.
Except
And
one
later
person
on,
was kept
this 5530 of writ petition was disposed of,
disposed of.
saying that let it be examined by the
DLC.
DLSC. DLSC says that the petitioner in 462 is senior
Madam.
and recommended as per the
As per the projection bid.
projection in that order. Then
Now,
what is there to review?
Madam, there are two things. Madam.
Hmm.
There, first of all, DLC has not recommended for provincialization.
Hmm.
DLC, the DLC send the for determination of seniority to the inspector of schools.
Hmm.
And the inspector of schools has passed an order.
Hmm.
After that, that order, my lord, will kindly find at page 52. That's a part of the writ petition. This was construed to be as a recommendation by the DLC. Page 52, my lord.
Yes.
May I read it?
Yes.
Seen the order dated 23/11/2015 passed by the Honorable Court in WPC number 533/2012, filed by Ahmed Ali Talukdar. The DLC Nagaon in its meeting resolved that as per provisions of the 4.2 of the Assam Venture Educational Provincialization of Services Act 2011 as amended on 2012, the provincialization of services of the employees shall be on the basis of seniority only in respect of category in the concerned school irrespective of any subject combination. Now, the Honorable High Court has disposed the writ petition directing the District Scrutiny Committee to dispose the petitioner's grievance within a period of 2 months from the date of receipt of the certified copy, along with the copy of the writ petition. The District Level Scrutiny Committee, in its meeting, directed the undersigned, that is the inspector, to issue a speaking order on the basis of a proceeding of the meeting dated 11/2/2016. Now, accordingly, the DLC perused and seen all the records pertaining to the petitioner's grievance and also re-examined the records particulars of the staff pattern submitted by the headmaster of Jungle Block High School in prescribed format to the District Scrutiny Committee for provincialization of services of Abdul Khalek BSc Respond number 6, Marjan Begum BSc Respond number 7, and Mohammad Ahmed Ali Talukdar petitioner. It has been found that the date of joining of Abdul Khalek is 17/11/1994. Marjan Begum is 2/12/1997, and Ahmed Ali Talukdar is 23/8/2004, which reflects that Mohammad Ahmed Ali Talukdar is junior most teacher amongst them. Hence, the service of Abdul Khalek and Mrs. Marjan Begum may be considered for provincialization. So, after this speaking order, it ought to have been a recommendation by the DLC, madam. Now, there was no recommendation by the DLC. This 37/2016. Thereafter, my lord, after this order was passed, that this act got struck down by this honorable court on 23/9/2016.
Abdul Khalek has filed 5330.
Yes.
Is it?
No.
Marjan Begum filed 462.
Ahmed Ali Talukdar filed 5330.
Oh, Ahmed Ali. Ahmed Ali Talukdar. He's found to be the junior most.
He's found to be the junior.
Then 462 is filed by?
462 is filed by the Marjan Begum.
Court direction was to the DLSC.
Yes, madam.
And DLSC in turn directed the inspector.
DLSC for determination of the seniority. DLC what they did. DLC on 11/2/2016 in its resolution has clarified that the subject combination would not be a criteria as per the section 4.2 of the Act of 2011. It is a seniority which will have to look into for provincialization. And accordingly, for determination, it was sent to the inspector of schools.
Senior.
Now, the inspector of schools on 37 has passed this order. And
So how many persons could be considered for provincialization?
under the Act of 2011, my lord, there was a schedule appendix.
There were 3 names.
Yes.
Now,
it should
Inspector
be
of School says that these 2 names may be
science
considered.
teacher, 2 science teacher.
Two
Two
posts.
2 posts.
Now, Act of 2013,
Act of 2011.
11.
Yes.
Was struck down.
Was struck down.
When?
On 23/9. 23, I'll give the date. On 23/9/2016, by the Honorable Division Bench in WPC number 3190 of 2012.
WPC number?
Act of 2000. WPC number 3190 of 2012.
2012. Division bench.
Division Bench 647.
Was that 647?
No, I was suggesting that.
Oh.
Page them. Now, your lordship will kindly see the 37/2016 order which I read, my lord.
Yes.
And the paragraph whereby this order is being annexed, that your lordship will find at page 29 of the writ petition.
Writ petition or review petition?
Writ petition. My lord, writ petition is annexed with the review petition. That is page 29. Para 9.
Yes, read.
The petitioner begs to state that finally this Honorable Court, vide an order dated 23/11/2015, has been pleased to dispose of the 530/2015, directing the district level scrutiny committee to examine the case of the present petitioner in the respond number 7 within a period of 2 months from the date of submitting the certified copy of the said order dated 23/11/2015, passed by this Honorable Court. Thereafter, the DLC in its meeting dated 11/2/2016 examined the grievance of the respond number 7 and resolved that as per provisions of section 4(2) of the Act of 2011 and amended Act of 2012, the provincialization of the service of the employees shall be on the basis of the seniority only in respect of the category in the concerned school, irrespective of any subject combination. Therefore, the DLC recommended for provincialization of the service of the present petitioner and one Abdul Khalek as the assistant teacher science of the Jungle Block, and thereby the DLC has held that the respond number 7 is not entitled for provincialization of service of the said school since he is the junior most graduate teacher among all 3 assistant teachers. In the said meeting, DLC dated 11/2/2016, the DLC directed the respond number 5 to issue a speaking order in this regard, and accordingly the respond number 5 issued an order recommending the services of the present petitioner and Abdul Khalek may be provincialized as a service of the assistant teacher. Well, the 11/2/2016, it was projected that 11/2/2016 DLC examined and recommended the name of the petitioner, whereas, and the 11/2/16 minutes is not a part of the writ petition. Whereas the order that is passed by the inspector 37/2016 is the part which I have read, page 52. Now this order simply determines the seniority, that the writ petitioner is senior and therefore her and Abdul Khalek case may be considered for provincialization. Now, inspector is not the DLSC. Inspector is a member secretary of the DLSC, but any recommendation under the Act of 2011, Section 10 lays down the entire procedure, how a provincialization will be effected. Now, there are twofold in this order, against which I am seeking a review. One, there is, first of all, there is an apparent error in the face of the record that there was no recommendation by the DLC in favor of the petitioner for provincialization. DLC in its minute of 11 to 2016 only clarified that it would be the seniority which will be taken into consideration, not the subject combination. And therefore, for the purpose of determining the seniority, it was sent to the inspector of school. And after the inspector of school has passed this order on 37/2016, as the act got struck down in 23/9/2016, so it could not, the DLC could not recommend the name of the petitioner. Now, the second fold of the order is that the Honorable Court has held that it is a case of deemed provincialization, and as the DLC has recommended, therefore the petitioner would be entitled for provincialization with effect from 1/1/2013. All of this aspect has been clarified by this several judgment of coordinate bench and the division bench of this court, where the until there is a notification under section 10(4) of the Act of 2011, there is no right accrued under section 4 for deemed provincialization. And more so, in view of the judgment of the Honorable Apex Court also, now once the act is being struck down, there cannot be, it is an honest in law, there cannot be any right, enforceable right under the act which has been struck down as unconstitutional. So I'll place those judgment. May I just first read, section 10, Page 658, find in the book.
Yes.
Section 10, District Scrutiny Committee. There shall be one district scrutiny committee in each district separately for elementary, secondary, and higher education to scrutinize service records and other related issues of the serving teachers and staff of venture education and institution pertaining to provincialization of their services. The Deputy Commissioner of the district by an order shall constitute the district scrutiny committee for the respective district under the preceding subsection. The district scrutiny committee shall first scrutinize and prepare the list of all venture educational institutions within the district which are eligible in terms of the provisions of this act, and shall thereafter proceed to scrutinize and verify the service records of all the serving employees who are eligible and would become eligible for being considered for provincialization of their services. The district scrutiny committee, Your Lordship, will mark this 10th formula. This is very important. The district scrutiny committee shall forward the verified list of the eligible teachers of school-wise in accordance with the number of the posts specified in the schedule appended to this act to the concerned director, who shall, after making such further scrutiny as may be required, shall forward the same to the concerned department of the state government for consideration and for issuing notification in the regard of eligible institution and employees eligible, employees eligible for getting their services provincialized. The district scrutiny committee shall have the power to inspect all documents, records produced before it, and call for it such records and documents as may be required for the purpose of causing verification and scrutiny and examining witness for the purpose. If considered necessary, while doing so, it shall have the power of a civil court for the purpose of compelling attendance of the person and production of document. Now, my lord, 7, Your Lordship will kindly see the composition of the district scrutiny committee of the secondary division. The district scrutiny committee for secondary education shall be constituted with the following members, namely the deputy commissioner or his nominee or not below the rank of the additional deputy commissioner of the concerned district chairman, the inspector of school member secretary, one principal of the junior college to be nominated by the inspector of school, one principal of the provincialized higher secondary school to be nominated by the inspector of school, one headmaster of the provincialized high school, high madrasa to be nominated and the inspector of school members, one eminent person in the field of education to be nominated by the deputy commissioner member, one retired principal headmaster to be nominated by the inspector of school. So without this composition, the recommendation that is made by at page 52, that the recommendation which has been constituted to be a recommendation by the DLC, it's in my humble submission, is not correct. The inspector has just determined the seniority and has, in fact, from the order itself, my lord, will see page 52 once more, my lord, last line. Hence, the services of Abdul Khalek and Marjan Begum may be considered for provincialization. So it cannot be a recommendation by the district level scrutiny committee, my lord.
Yes.
Am I clear on this, my lord? That the finding of the honorable court that there was a recommendation by the DLC in favor of the petitioner was, my lord, apparently error, my lord. Because the writ petition, my lord, there was no recommendation in the writ petition, though in the paragraph 9 it has been projected that on 11/2/2016 the DLC recommended in favor of the petitioner for provincialization, whereas, my lord, that minutes is not a part of the record. And page 52, that order clarifies, my lord, what was the minutes of 11/2/2016. Now, in respect of the second direction, my lord, that as it is a case of deemed provincialization under the Act of 2011, my lord, may I just place some judgments, my lord?
Let us read the first direction again.
Sorry,
Paragraph
ma'am.
4, is it?
Sorry, ma'am.
Is it paragraph 4?
Paragraph 4. Paragraph 4. WPC 533/2012 was given a final consideration by the order dated 23/11/2015 with a direction to the district level scrutiny committee, in short, DLSC, to examine the claim of the respondent number 7, Mohammad Ahmed Ali Talukdar. The DLC, upon examination, arrived at its conclusion that the writ petitioner, Marjan Begum, is senior to Mohammad Ahmed Ali Talukdar and therefore would be entitled for provincialization. The writ petition is instituted that nothing further has been done and the recommendation of DLC made in favor of the petitioner had not been acted upon. So, in my respectful submission, my lord, the page 52 order is construed to be an recommendation by the district level scrutiny committee. Whereas, my lord, the contents of that order clearly indicates that the district level scrutiny committee on 11/2/2016 has only observed that it would be the seniority which should be taken for consideration, because the issue in 533/2012 was with regard to subject combination. And DLC on 11/2/2016 held that the subject combination will not be a criteria for provincialization, it would be the seniority. And therefore, it was remanded back to the inspector of school to determine seniority. And page 52 is an order determining the seniority.
Yes.
Yes. Now, if your lordship,
That's the first part. You say the second part is there also?
yes, the second part is, my lord, with regard to a direction that it is a both observation and direction, my lord. As it is a case of deemed provincialization under section 4(1) of the Act of
Oh, that
2000
retrospective effect.
Yes. My lord, if there is, first of all, if there is no recommendation by the DLC, my lord, in my respectful opinion, the second would not come. And even though, assuming, my lord, that there is a recommendation by the DLC, my lord, that would also not confer a right of provincialization under section 4 until the procedure that is laid down under section 10(4) is completed. And this has been held by the coordinate bench of this honorable court and the division bench.
Take me to your grounds.
My lord.
The grounds you have made.
My lord. Page 10, my lord. With regard to the paragraph 4, that ground, my lord, you will find page 12, ground F. Page 12, my lord finds.
Yes.
Now, with regard to the section that the finding of 4(1), my lord, may I just place some judgments?
With regard to finding what?
Finding with regard to the that it is a case under deemed provincialization under section 4(1), as the DLC has recommended.
But the act
the
itself has been struck down.
Yes.
Then what happens now?
There cannot be, in fact, this order would not hold because once the act is being struck down, my lord, so there cannot be any mandamus for provincialization under the Act of 2011. Even the recommendation by the DLC, my lord, ipse dixit would not confer any right for provincialization, my lord, because DLC is 2016.
In the writ petition in 2011, 21.
2020.
To take certain actions in
Yes.
terms of the 2021 Act.
2011 Act.
Sorry, 2011 Act. Is that possible?
No. That's also one of my ground of review, my lord.
But then why didn't you file an appeal instead of review?
But review, my lord, because of this fact, my lord, the Honorable Court construed this order of 37/2016 as a recommendation by the DLS. That are error of facts, my lord.
So that further fresh exercise is not required.
Hello.
As per the court.
My lord.
No further exercise was required.
My lord.
Because this is a recommendation itself.
Yes.
Order passed by the inspector.
Inspector of schools.
But where's the order of the DLST?
DLS is, my lord, this is not a part of the petition. It was never a part of it. That's what I wanted to show you.
That you should bring it now.
Hello. Paragraph.
Because your entire case was that DLSC has taken a call.
Lordship will kindly see page.
Except for the seniority part.
Yes, page 52, the order of the inspector is clear about that, my lord.
52.
Page 52. The 37/2016 inspector's order.
Which part? Which part?
The second paragraph.
Why don't you produce that 11/2/16?
11/2/16 I can, my lord.
Huh?
I can.
You produce, let's see what is the written there.
No problem. Even in the objection that is filed by the respondent here in the review petition, also have not brought this 11/2/16. Though a statement was made as per record in the repetition.
Of which district? Nagaon?
Nagaon.
Who can bring it?
I can
You can bring it. When can you bring it?
Immediately on reopening.
Mr. B. Kaushik, please write down. Learned counsel for the review petitioner to produce the speaking order dated 11/2/2016 of the DLSC.
Say minutes of the.
Or to produce the minutes of the meeting dated 11/2/2016 of the DLSC Nagaon in connection with WPC
5330/2012.
WPC number 5330 of 2012. List the matter again also and so.
Great one.
None appears for the petitioner when the matter is called. Same was the case when the matter was listed on 12/2/2024. First up, it appears that the petitioner is no longer interested in the matter. The petition stands dismissed for non-prosecution. Mr. B. Kaushik. So sorry, F. Ugan Learned Counsel appears for the secondary elementary education department.
Wait, please, Lordships. Because this matter relates to payment of arrears salaries of the petitioner. Because the petitioner was appointed as a part-time sweeper on contractual basis in the Director of Madrasa Education in 2013. So she continued with her services, but she was not paid salaries from April 2014 to October 2014 months. So
who's respondent number 5?
Respondent number 5 is the person who was sought to be appointed in my place. So I came before this honorable court, a stay was granted. So I had taken steps and services deemed to be complete on the respondent number 5.
Stay was granted?
Yes.
On the appointment of respondent number 5?
There was a stay with regard to the status quo order. 7/12/2017 order. Take up that order.
7/2. 7/2.
7/12/2017.
Okay, 7/12.
On the third page, last paragraph, others will find it. I was allowed to continue.
To the post of sweeper?
Yes.
Under whose establishment?
The Directorate of Madrasa Education.
Okay. And what is the role of respondent number 5?
No, the respondent number 5 was appointed since he was sought to be appointed in my place. So
To replace you?
Yes.
But where's the order?
There is no, I do not have any order because since November 2017, I was not allowed to sign the register, attendance register. So I inquired and I found out that the respondent number 5 was sought to be appointed in my place. I immediately came up before this honorable court.
You don't have the appointment order?
No, I don't have it. Plus, in any case, the Director of Madrasa Education is not there at present. The Madrasa Education Act has been repealed. So my only prayer at this stage is with regard to the arrear salaries from April 2014 to October 2015.
Yes, who's there?
Lordship can direct the Director of Secondary Education now to examine the claim of the petitioner in respect of the arrear salary for the period April 2014 to 15.
Just a minute. Before that, what is the period?
April 2014 to October 2015.
2014
2014.
to October 2015.
Yes.
Now you say that what is no longer there now?
The Director of Madrasa Education is no longer there.
Directorate of
Madrasa Education. Madrasa Education Board.
Madrasa Education Board has been done away with.
Replaced by what?
It has been merged with the Director of Secondary Education.
Secondary Education.
Madrasa Education Board.
Yes.
Merged with?
The Directorate of Secondary Education.
Did you work?
Yes, I worked.
Since
In
when?
fact, I was working since 2013. In fact, if my lord sees
You are working since 2013.
8/11/2013. In
Okay.
fact, in that particular order. of
Then
this
when
order,
did you discontinue?
I was working till 31/10/2017.
Then
Then I was sought to be replaced by the respondent number 5. I came up before this honorable court.
an order was passed on which date? Interim order?
7/12/2017.
Then you worked.
Yes. The current salaries were paid, but that arrear salary of that particular period was not paid. In fact, that has been recorded in that particular order. The standing council had submitted on.
So we'll dispose it off in that line then.
Well, let the Director.
Who will examine?
Director of Secondary Education, Assam.
Okay. Heard Mr.
S. Vishwakarma.
S. Vishwakarma, learned counsel for the petitioner, and Mr. B. Kaushik, learned Standing Council,
Secondary Education.
Secondary Education, appearing for respondent numbers 1 and 2.
My lord.
Who else is there? Anyone else?
No,
5 has,
5, none is appearing.
none has approved.
What, 3, 4?
3, 4, my lord, as non-existing.
None appears for respondent number 5 despite notice. Mr. As for respondent numbers 3 and 4, that is State Madrasa Education Board, the same no longer is in existence and has now merged with the Directorate of Secondary Education. Next paragraph, by filing this writ petition, the petitioner has paid for a direction for payment of arrears salary with effect from April 2014 to October 2015. Since he has been discharging his duty as sweeper under the establishment of the respondent number
3. 3.
3. Although there are other prayers as well, but Mr. Bishwakarma, Learned Counsel, submits that due to the change of the situation, the petitioner restricts his claim to the area salaries for the aforesaid period. Next paragraph, Mr. B. Kaushik, Learned Counsel, submits that although the petitioner has made such claim, but unless the same is duly verified by the authority concerned, it will not be possible to accept such a claim. Stop considering the submissions made by the rival parties. This court is of the considered view that no useful purpose will be served for the matter to be pending, to keep the matter pending. Stop. Accordingly, the writ petition is disposed of with the direction to the Director of Secondary Education, bracket respondent number 2, to examine the claim of the petitioner for payment of arrears salary as sweeper from the month of April, with effect from April 2014 to October 2015. Stop. Upon such examination, if it is found that the petitioner has indeed been rendering his service, the authority concerned shall release his arrears salary without delay. Stop. It may also be noted that on 7/12/2017, when notice of motion was issued, an interim direction was passed by this court to allow the petitioner to continue in his present post. To stop, the petitioner claims that he has continued as such and has been paid his current salaries except the arrears salaries. Stop. Next para, accordingly, the writ petition stands disposed of in the above terms, and the respondent number 2 shall do the needful as expeditiously as possible and preferably within a period of 2 months from the date of receipt of a certified copy of this order.
Deeply obliged.
May I please, Your Lordship?
My lord, matter pertains to provincialization of services of the petitioners, my lord. Earlier, what happened in this case, my lord, there were two schools having same name, my lord. And accordingly, the petitions were preferred, my lord. And the director, by virtue of order, lordship will find at page 76, my lord.
But how is it possible with two schools with same name?
My lord, my school has been already been, my lord, given the genuine school, my lord. It has been regarded to be the genuine school by virtue of the writ petitions out.
Genuine school and not genuine school.
As well as,
It's ready, my lord, ready to file, my lord. Next week we will file.
my lord, I have objection, my lord, because the case has been already been listed for 8 to 9 occasions, my lord. They have not filed their
So,
affidavit.
my lord, my learned friend.
I have challenged something else, my lord. Lordship will kindly have a look in the last page of my writ petition, my lord.
What have you challenged?
I have challenged, my lord, this particular, my lord, finding of the, my lord, the concerned, my lord, director, my lord.
Page,
Later on, my lord,
page 100?
Page 99, my lord.
99.
99 minutes. The top paragraph, my lord. In
What
view
is
of the
page
above-
99?
Yes.
What is page 99?
Page 99 is the, my lord, finding of the, my lord, order passed by the impugn order, my lord.
Dated?
Dated 28th of April, my lord, 2022. My lord. That was put to challenge, my lord.
Just a minute.
My lord.
I'm not able to locate your 99.
It
Okay,
starts-
yes, 28, yes.
Yes, it starts from page 97
Mm.
and ends in page 99, my lord. In the top paragraph, it is written, my lord, in view of the above, the committee examining the stated facts is of the view that there's the school so-and-so with dias code number so-and-so doesn't fulfill the criteria as laid down in the clause 3(1) Roman 12 of the Act 2017. Since the enrollment position of the school during the year 2016-17 is shown as no enrollment on UDIAS in the database maintained by NUPA for the year 2016-17. Now, my lord will kindly go to the inspection report, my lord, which was issued by the concerned authority, my lord, page 84, my lord, annexer 18, my lord. Page 84, my lord. Page 84 is a, my lord, inspection report, my lord, and 85 is a vernacular. This is an inspection report, my lord, pertaining to, my lord, 5th of May, my lord, 2017, my lord. And if we count the number of students, my lord, the total number of students right from class 1 to 5, my lord, is 160, my lord. Therefore, my lord, in my humble submission, my lord, the finding made by the, my lord, concerned director, my lord, is not sustainable in the eye of law, my lord. And regarding the dias code, my lord,
Class 1 to class 5.
yes, class 1 to class 5, the total number of students seems to be 160, my lord. In the left side, it is the number of boys, and after stroke, the number of girls are there, my lord.
Okay. Like class 1, 22 will be
Boys,
what?
my lord.
Boys.
Yes, and 15 will be, my lord, girls, my lord.
How do you say it's not the other way around?
My lord, in the vernacular also, my lord, it is written, my lord, in the inspection report itself, in the next page, my lord, in the vernacular.
How it is written?
This is how, my lord, it was written by the, my lord, concerned SI of school, my lord, sub-inspector of schools, my lord.
No. My query is that 22 slash
There's no heading, my lord, I understand, my lord.
22 slash 15.
Yes, my lord.
You say 22 is boys, 15 is girls.
Because, my lord, we have already dealt with many
It could
cases.
be 22 girls and 15 boys also.
Maybe, my lord, but the heading should have been made, my lord, regarding the boys and girls. But I'm very sure that these are the boys and for boys and girls.
Anyway, for the present purpose, whether it boys or girls doesn't matter.
Yes, my lord.
Number of students is required.
Number of students are required.
You have added up the students. How much?
160, my lord.
Page 99 again.
Yes, my lord. Page 99, my lord.
What is the beginning part of this? This is by the
Beginning-
director.
Yes, the state level scrutiny committee, my lord.
Now you tell me the whole
previous
story.
page, my lord. From the previous
See,
page.
just a minute. You have not told me the whole story. There's an writ petition also mentioned here.
Yes, my
Is
lord.
this a second round?
This is the third round of it.
Third round?
Yes.
First round is which number?
First round is, my lord, it has been mentioned in the speaking order also, my lord. If we go, there are
Number?
number of page 76, my lord. Page 76.
Why 76? I think 97 also might contain that.
There are several writ petitions, my lord, which were filed, my lord.
No, tell me the first one. Which is the first one?
First one is, my lord, 5638 of 2014, my lord.
Okay, first
It is
one.
mentioned is In my lord.
Okay, then second one,
Then again, my lord, I preferred one, my lord, appeal under section 14 of the, my lord, 2017 Act for consideration of my school, my lord, services, my lord. Thereafter, my lord, again I filed one writ petition, page number 92, my lord, WBC 1386 of 2021. Page 92, my lord.
just a minute. 1386.
1386 of 2021.
Okay. Now, first, before that, you tell me what happened in this case, 5638 of 2014?
5638, my lord, in respect of that writ petition, my lord, the director was directed to conduct an inquiry of both the petitioners as well as the private respondents. And
What was the subject matter?
the subject matter was almost similar, my lord.
Dispute.
We claim dispute.
Which school has?
Which school is genuine, my lord?
Genuine.
Yes, accordingly, my lord, a thorough order, detailed order was passed by the, my lord, the concerned director, my lord,
So
discussing.
the matter was relegated to the director.
Director, my lord.
Then director passed some order.
Some order, my lord.
In favor, against you, perhaps.
In my favor, my lord.
Then why did you file second writ petition
My
then?
lord, second writ petition was preferred before the, my lord, High Court, my lord, since I preferred an appeal, my lord, under section 14. That was not taken into consideration.
Why did you file appeal?
My lord, for consideration of our services, my lord. Lordship, I have everything is a part of record. Lordship will kindly go.
No. See, first writ petition is 5638.
Yes.
You say that direction was given to the director to find out which is genuine.
Yes.
And you said order was passed in your favor.
In my favor.
Then why did you
Therefore,
go?
we made a prayer. There is a story, my lord. Since there was a dispute between the two schools, my lord, the Dias Court was blocked by the concerned authority. That was not released, neither, nor it was, my lord, issued afresh, my lord.
Who's
This particular.
Who's the concerned authority for Dias Court?
My lord, the mission director, my lord.
Mission director, not the director. Not the director of elementary.
Not the director.
SSA is the.
SSA is also a party, my lord. They have not released. In fact, my lord, in this regard, the concerned district elementary officer, my lord, he is the district mission coordinator, my lord. District mission coordinator. He has also written one communication, my lord.
See, I think then let him file his affidavit since he's got the instructions.
Yes.
So
Affidavit will only reflect, my lord. There are some other, my lord, directions issued by.
you already know what he's going to say.
Yes.
No. No, he was trying to produce on the day of, my lord, the inspection, last inspection, my lord.
Have you shared your documents with him?
No.
He knows what you're going to produce. Then?
Well, it was produced on last 2-3 occasions. I'll leave it to lordship. They may file the affidavit.
Mr. Pegu, you are repeating the same prayer every time.
No,
Or
my
what?
lord, in this case, my lord, my friend S. Sutia is prepared the affidavit. He is not well, my lord. So next week he will file well with that.
All right.
On last day, S4 was.
I'll leave it to lordship.
We'll fix a date.
My lord.
Are you sure you have the instructions with you?
No.
Then,
My lord, that instruction with my learned friend S. Sutia.
no, that's what.
Yes.
Mr. Sutia has got the instructions.
Yes, sir.
He has the instructions.
Yes, sir.
Are you sure?
Yes, sir.
Then next day you should not come up and say that I don't have the instructions.
No, come on. I have communicated with her.
Mr. G. Pegu, learned counselor appearing on behalf of Miss, is it?
Yeah, yes, sir.
Miss S. Truthia, learned counselor appearing for the Elementary Education Department, submits that she has already received instructions and prays for 2 weeks' time on our behalf to file the counter affidavit. Mr. Your good
Zed
name?
Ahmad.
Z.
Ahmad.
Hamad.
Yes, ma'am.
Mr. Z. Hamad, learned counsel appears for the petitioner. Considering the submission made, 2 weeks' time is granted as paid for. List the matter again on so and so. 5th August.
Given mission.
Obliged.
I wait. I'm deeply obliged.
Nobody's there?
Sorry, Lordship. May I please, Lordship? Well, in this case, my lord, the petitioner number 1 is my lord 4 years baby, Lordship. And 2 is his my lord maternal grandmother, Lordship. My lord, the mother of the petition number 1, my lord, living 7 days, at the age of 7 days, Lordship, expired, Lordship. Since then till today, my lord, he is under custody of the petitioner, Lordship, number 2, Lordship. My lord, there is scheme of the government, Lordship, my lord, after the death, my lord, died on harness, Lordship. My lord, kin, my lord, next of kin, my lord, is entitled to, Lordship, the full salary, Lordship, until the date of retirement, Lordship. Now, petitioner's mother was my lord, school teacher, Lordship. She died. Yes.
School
Lord.
teacher.
Yes, Lordship. Now,
Which
her
school?
husband has, my lord, remarried, Lordship. He is not entitled, Lordship.
Which school? High school, middle school?